All right, I've gotten the official thumbs up to start. So good morning. My name is Robert Ruffner. I'm the Executive Director of the Maine Indigent Defense Center. I want to welcome you all to this forum on indigent defense in Maine. I want to start by thanking the Maine Monitor for partnering with us to put this on. Mika, the Executive Director, and also our panelists, Stephanie and Josh, who will be asking the questions to the panel this afternoon. I want to welcome those who are watching on Zoom, as well as those who are watching a recording of this. Unfortunately, when we scheduled this, we did not know the schedule of the legislature, and they are in an all-day session doing a number of votes for leadership and other positions. And I know of a couple of legislators, at least, who have expressed an interest in watching the recordings. So I appreciate your interest in doing so. I want to thank the panelists who have agreed to participate and come here as well. Ron Schneider, Tina Netto, David Carroll from the Sixth Amendment Center, Professor Branch, and others who have not yet arrived, I think. I also want to thank the interns and externs at the Maine Indigent Defense Center over the last year who have worked in collecting data and expressing an interest in indigent defense. Some of their work is on some posters on the table outside, as well as there's a good showing from the Maine Law's students for the Sixth organization who are here, and we appreciate their interest and contributing to the ongoing discussion on this topic at the law school and in other forums as well. And I want to thank most of all our policy and developmental director, Emily Goulet, who without her organizational skills and drive, we wouldn't be here today. So she's really taken the Maine Indigent Defense Center from something that was how much time I had at 3 a.m. when I wasn't sleeping to something that is a real concrete organization that is moving forward and growing every day. So why are we here today? In part because of the Sixth Amendment. It reads, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district where the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature of and cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. That amendment was ratified in 1791 to our Constitution. Whether we as a state are living up to that ideal is really in doubt. While there have been great changes over the last 15 to 20 years in how Maine provides representation for our poor and those in need, the question still remains, are we meeting our obligations as a state and as a society? Why do we do this? What is the reason that someone should have an attorney? Why would we as a society want this to happen? A lot of times we talk as lawyers to other lawyers, and we use legal speak, like the language of the Constitution. But if we're going to progress beyond just words and beyond just ideas on a piece of paper, we need to really expand beyond just looking at this as lawyers, looking at it more as a mechanism or a piece of machinery in our society. What are we trying to achieve, and what sort of things in cases and controversies, and frankly, people, are we putting into our criminal system? There's lots of oft quoted phrases about the Sixth Amendment, about how without the guiding hand of counsel at every step in the proceeding against him, that an individual is at risk to being improperly convicted. That's from 1932, misquoted. 31 years later in Gideon, we have language by Justice Black, again off-quoted. Lawyers in criminal cases are necessities, not luxuries. But what does it really mean? Attorney General, or former Attorney General, Janet Reno, talked about the difference that an attorney can make. A competent lawyer will skillfully cross-examine a witness and identify and disclose a lie or mistake. A competent lawyer will pursue weaknesses in the prosecutor's case, both to test the basis for the prosecution and to challenge the prosecution's ability to meet the standard of proof beyond a reasonable doubt. Again, what does that really mean to us as a society? The point she was trying to make is that in the end, a good lawyer is the best defense against a wrongful conviction. However, what we do as lawyers is so much more than just trial work, just preventing wrongful convictions. We often are dealing with individuals with so many unmet needs, so many problems that aren't legal. Mental health, substance abuse, poverty and housing related issues, immigration related issues. More and more we are finding that our clients in the system are there because the rest of our system of government and the services it's supposed to provide isn't providing the services that it should be providing. And so our clients end up in criminal court, and the prosecutors and the judges look to us to somehow fix it all. We have, as you all know, an issue with being able to provide even any lawyers to people entitled to them in Maine. Over 1,000 cases are currently unstaffed between adult criminal and child protective and juvenile and appeals, as far as we know from the judicial branch. Much of the current discussion is about how can we get more lawyers? How can we get more defense lawyers? If all we do is talk about just that one component to the system, we leave on the table a number of other issues. How can we achieve better and more just results for clients outside of the criminal system? How can we identify problems in our society that lead to conduct that we currently dump in the criminal courts? What is the best way as a society to address those needs? Today, we're not going to solve all those issues, but hopefully we'll have a discussion about how we got to where we are currently in Maine, how other states are dealing with some of the crises that they are facing, and then what can we do as some concrete next steps. I know that this is a topic that is often discussed. And it seems, as some of the panelists know, that we are rehashing the same conversations from years and years ago. But hopefully, by having a conversation with a broader audience, not just those in the system, amongst prosecutors, defense attorneys, and judges, we can move the conversation to not just about the law, but about the type of society we want, and can we make it a more just one? So I'd like to introduce the moderator for the first panel, Josh Keefe from the Maine Monitor, and the other panelists on today's first panel are Tina Netto, the Executive Director of the Maine Association of Criminal Defense Lawyers and a longtime criminal defense attorney who does almost exclusively indigent defense work, and Ron Schneider, who is a Maine law graduate, wrote his law review article on the issue of the need for a public defender system in Maine. How many years ago, Ron? 1996. He was on the Clifford Commission, which the judicial branch put together to get indigent defense out of its budget, and was the first chair of the Maine Commission then on indigent legal services. So thank you all for being here. I'm sorry that I've droned on, but I appreciate you all taking the time and interest on this topic. Thank you.
Thank you for being here. My name is Josh Keefe. Is that too loud? That feels too loud, but good. All right. I'm Josh Keefe. I'm the government accountability reporter for the Maine Monitor. It's a nonprofit newsroom covering our state. I'll be quick, but I'm sure everyone here knows about Maine's indigent defense crisis, but I thought it might be helpful to just briefly describe the situation as it stands now. But first of all, I think it's worth saying that in August 2023, there were roughly 100 indigent criminal cases in need of attorneys. And at that time, Chief Justice Valerie Stanfield described the situation as a crisis. If 100 cases constitute a crisis, then I think we need some new word to accurately describe the situation as it stands now. As of yesterday, there were 972 criminal cases in need of a appointed defense attorney in Maine. Those cases represent nearly 800 individual defendants. Nearly 150 were in custody, and that's just the criminal side. There are another, again, this is my counting a spreadsheet up, but 170 parents in child protection cases waiting for an attorney, as well as several more cases in need of guardians ad litem. Maine is certainly not the only state with these problems. Some states don't even have the capacity to track these numbers. But in Oregon, for example, the number of criminal cases in need of a public defender stood at 3,200 in May. And that's when the Ninth Circuit Court of Appeals ruled the state had to release many indigent criminal defendants within 7 days if they weren't provided counsel. In that majority ruling, Judge John Owens wrote the following, which I think will be helpful to consider as we move forward today. He wrote, "The state arrests a citizen and incarcerates him pending trial. Days, weeks, and months pass without any legal representation. He seeks relief from the authorities. Surely a lawyer should help him. In response, he gets a shoulder shrug, a promise that they are working on it, and nothing more. He remains in jail without legal counsel or any relief in sight." You might think this passage comes from a 1970s State Department report on some autocratic regime in the Soviet bloc. Unfortunately, we do not need to go back in time or cross an ocean to witness this Kafkaesque scene. This is the state of Oregon in 2024, end quote. And I think we could all see that that could just as easily have been written about the state of Maine. There are steps being taken here. For the first time, Maine is opening public defender offices across the state. The ACLU lawsuit seems to be heading for a resolution sometime soon. But obviously that is a little comfort to people currently in jail, unable to secure the attorney the Constitution guarantees them. So how do we navigate the current situation and how do we get here? And to help us answer that is our panelists. I'll ask some questions. I haven't gone to law school, so if I'm off, if you guys want to take in different directions, please feel free. I'd love to have a sort of free-flowing conversation. There will be time for questions at the end, and if you're on Zoom, you can put questions in the chat and we will get to them. So to get started, I guess the big question is, how did we get here? And maybe, Ron, sounds like you've wrote about this quite a while ago. Maybe we'll start with you. I want to get all your perspectives on this, but how did we get to the place we're at today?
Um, I don't know, how many hours do we have?
Yeah.
I think
It's on. One of the things that I wanted to say, I went back into to read something, and it goes to what Rob was saying about why we care about this. And I am going to quote myself and Justice Dana, Howard Dana. And what I wrote then was essential to being a member of American society is a healthy distrust of the power of the state. Part of being a person in the United States means that one can challenge the government's power to take away one's life, liberty and life. When a person is denied the opportunity to challenge effectively the government's power, that person has designed some of what it means to be a person in our society. And Howard Dana, the director of Legal Services Corp, said at one point, anyone who values this society values our fundamental liberties, has a stake in making sure that justice is available to everyone. So, I mean, I think that's a little bit of the non-legal reasons for caring. I guess for me, it started when I was a student attorney and had was representing people in court and had a jury trial as a student attorney on a felony assault on a police officer, and was handling an OUI manslaughter case, and thought, this is not really right. But then being in court, not a full-time criminal defense attorney, saw problems with the way things were going. You know, there was no application, there was no standards, no oversight. Judges would say to recent grads, come on over and put your name on the list, get some experience. And as a person who was there part-time, I saw things that were problematic and nobody was really doing anything about it. And I thought a public defender system, based on my experience of listening to people mostly in New Hampshire, I thought this was the way that we should go. So fast forward, this man, Rob, is on a mission of a lifetime, and is moving forward, help create the Clifford Commission. And we came up with the Maine Commission on Indigent Legal Services. I think it's important to understand that while that was discussed, while Rob had his reasons, I had my reasons for why we wanted a individual commission created, it was originally a financial issue. The judiciary had typically delayed payments to people. You run out, you know, the judges would cut fees for the lawyers. They'd present their invoices, the judges would cut them. Sometimes they would run out of money and people would have to wait 3, 4, 5, 6 months, wait till the next fiscal year to get paid. And at one point, the budget overrun had blown a $2 million budget hole in the judicial branch. So the chief was desperate to get that out of her budget. And so that moment helped create the commission. From day one, I will tell you this, I think it's okay, it wasn't completely confidential. But as he signed the bill to create the Maine Commission on Indigent Legal Services, Governor Baldacci looked up and said, so this isn't going to cost any more money, right? I mean, yeah, it's a true story.
you would die now.
Yeah. So we knew from the very moment this was underfunded. We knew it was gonna. So what happened is we created the commission, turned the lights on, created a system so that people get paid. People got paid regularly, and then we spent almost all of our time begging for more money. We created standards, an application, the specialty panels. There was more work to do. I was a member of the ACLU, so I didn't get reappointed by Governor LePage. although he didn't realize we probably agreed on more than with respect to this issue. But then things started to fall apart, really. The new members weren't appointed to the commission. The standards weren't being enforced. People were being allowed to, it was artificially being held up. And so these specialty panels that we created to try to ensure that people had the skill to do the work, a homicide case. I know some domestic violence cases, you know, serious felonies. We thought people should have, imagine that, we thought that they should have more than just being out of school and having taken a 1-day or 2-day training. The largest one, and I'll just say the judiciary, there was so much opposition to that. The Judiciary Committee room where we held the public hearing was packed with people opposing those specialty panels because it would hold people accountable. We actually got letters from people saying, this is going to hurt my ability to build a practice.
Ron,
When you say
when you're
people-
saying people. who are
Sorry.
you- yeah,
Oh,
you
lawyers,
always think it's
lawyers, sorry, lawyers,
Defense lawyers.
defense lawyers, right.
At the time.
People, I did break the rule a couple of times on public hearings and cross-examine people a little bit on what they were actually saying and ask them, so you think that you shouldn't have to have had a jury trial before trying a Class B felony? You know, you shouldn't have had that experience. And most people could not admit that and say, sure, you should just do it, wing it for the first time. So anyway, it rolled along. Interestingly, we got pushback. I do want to say this, we got pushback from the Maine State Bar Association Young Lawyers section because this was going to interfere with young lawyers' ability to, again, enter the world of law and build a practice. That somehow there was, people perceived a right for the lawyers to represent people who the state wanted to put in jail. By definition, everybody's looking at jail, right? That's how you get a lawyer. If you're not, if the state's not going to try to put you in jail, you don't get a lawyer in Maine. So anyway, it rolled along, kind of started to really fall apart. And then there was a deep concern about the money. Came back in 2019 with a newly established commission with 9 members. I rejoined with some of the current members, and then COVID hit, and everything went to hell. And I'm going to shut up in a second, but where I think why we are here we are now, because people like me failed in the ability to make something happen that we wanted to have happen. And I don't know if anybody's ever read Robert Caro's book about not Robert Caro, is it Robert? Sorry, about Robert Moses, about the power broker.
Yeah.
And how he wanted to do something. He had this vision for New York. And the first time he tried it, he failed because he didn't have any power. So then he spent his life amassing power and steamrolling everybody to get what he wanted. We didn't have power. I didn't have power. We tried to influence power. We influenced the Judiciary Committee. Didn't make a difference for the appropriations. It didn't make a difference with the governor. So the people in power didn't create what needed to be created. So what I used to say to people who were trying to say, it's going to have to all fall apart. It's going to have to crash. And that's what it did. And that's why we are where we are, where it crashed. And now we have people saying, oh, well, now we have to create public defenders offices. But COVID obviously changing demographics, younger people wanting to not, the cowboys of the 70s and the 80s who went out and, like the great lawyers that I worked with, you know, people like Peter Rodway, went out, hung his shingle. There were fewer of those people. Most people want a job, they want a salary, they want benefits, they want vacation. And the money just, it's very difficult to run the business. And COVID wore people down. It created a backlog in the court system. the judges became unyielding as they're trying to clear their dockets. And that's why a lot of people started to leave. And
Ron, could you define soon when you said you were going to stop talking soon?
now,
Okay.
so that's why I think we're here.
I guess I'm curious. It sounds like in some ways you're describing almost criminal defense lawyers almost being protectionist about maybe their business interests in all this. And I guess I'm wondering if Tina or Rob, like, it has sort of the defense bar contributed to this in some way, or I mean, I don't know. You want to take that however you.
Yeah, I'll speak to that. So I am the executive director of MACDOL. That's what we call our organization, MACDOL. I've been in this position for 7 years. I am well aware of the criminal defense bar pushing hard against the establishment of the commission, the establishment of any standards, the establishment of specialty panels. There was a huge outcry, I believe, in 2014 when then Governor LePage was not really creating a public defender's office, but he called it that. It seems as though for much of the time that the commission was established, anytime there was a suggestion that there might be either oversight or accountability or any of that, I think the private defense bar, of which, I mean, that's all we had, right, all this time, there was significant pushback, you know, absent a few people who have always, I think, been more globally minded about the issues of the system. So that has been a recurring issue. I will say, and one thing Ron didn't mention, in 2019, the Sixth Amendment Center, and I know David Carroll's here and he will speak, issued a report with basically the top 10 things that are wrong with our system. And that went over like a lead balloon in the Judiciary Committee, in the Appropriations Committee. I think a lot of the issues that were identified had to do with billing and oversight, but there were also indicators that there was no supervision or oversight of attorney quality. So if we're talking about the Sixth Amendment, sure, I guess billing is part of it. Money is always part of our analysis, but for me, it's always been a more qualitative issue. How are we ensuring that people are not just receiving constitutionally mandated counsel, but excellent counsel, because that's what they deserve? My perspective is not that. That was shared by, I would say, the majority of MACDOL members. We have about almost 300 members now across the state. And there was a lot of outcry, I think, when that report came out, as far as, oh, the attorneys are horrible. They're saying we're horrible. There was a significant lack of insight, I think, into what the report was actually trying to accomplish. And yes, in 2020, unfortunately, the wheels kind of fell off. And I think with this big C crisis, I don't have a better word for crisis, something that I've always thought, which is we need a public defender office in each district of Maine, just like they have district attorneys in each district of Maine. And then the private bar takes the conflict cases or the cases that the PD's offices aren't able to do. I think something switched where a significant chunk of the private bar saw that public defenders are not competition. They're necessary. We cannot do this work alone, clearly. I think it's essential in both making sure that the lower level cases are staffed appropriately, but these people are here. They are not just salaried and having benefits, but they are mentored, they are supported, they are trained, and we are developing, hopefully with this PD office program, the next generation of Maine defenders. It's vital. It's something that should have happened years ago. I'm glad to see the progress we're making. I'm a little concerned about what I've been hearing from legislative folks and other people in the governor's office regarding budget concerns for the coming biennium. as far as whether or not we'll be able to expand public defenders' offices, both the number of them, but also the capacity within those offices to take on a number of cases. Like I said, criminal defense attorneys have not always been the greatest friend to progress in this area, but I think having lived through what we've lived through and seen what we've seen, and too often I think the fingers go this way to us being the problem here. I am hopeful that the defense bar will be even more supportive moving forward for initiatives that help expand access to counsel and not take every change as a threat to them personally or their livelihoods.
All right. Rob, I'm going to ask you about, we've heard about, obviously, these problems go way back. The pandemic happens, but the number of cases have really expanded in the last year and a half. And obviously it's been I'm sure the pandemic plays into that, but it's 2024 at this point. I guess I'm wondering how you see that increase over the past sort of year. Like, why is it sort of coming to a head now and not earlier during the pandemic?
So I think it would be interesting to look at the population of Maine back in 2007 when the Clifford Commission was formed, and now, and then compare the growth of cases in the system in that time, because I am sure that it has outpaced the growth in our population by several fold. I think that the reason things have come to a head so much in the last 4 years is because the pandemic accelerated and exposed a lot of fault lines that existed all along, and not just in the criminal system. Much of our clients, as I mentioned, are there because other parts of the safety net as a society that we think exists, when we don't have to take advantage of it or seek help from it, we think that there's this safety net that exists, really isn't there. And so the pandemic accelerated the number of people that had needs that couldn't get them met, which without other options, they end up getting dumped into the criminal system. In my office, we see a huge, not a huge, but a large percentage of cases of clearly individuals that need some mental health counseling, casework, and treatment that are in the criminal system. So the lack of services, the difficulty getting services, drove more cases into the system. In addition, like every other industry, the last 4 years caused people to re-examine what they were going to do as careers and do in work. And the number of attorneys who decided to retire or move on to other types of work was accelerated by COVID. And at the time when people were examining from a business standpoint, I think when COVID started, we were still at $60 an hour that a law firm would get paid to have their attorneys represent individuals in court. And so I think that during that time when people were doing the numbers, less of them viewed that as a viable business and, frankly, family option, and being able to support themselves and their employees. And then everything was masked by Zoom, because when we first transitioned to remote court and remote appearances, the capacity was artificially increased. The attorneys that were stuck with this and were dedicated to doing this work, when you can appear in 4 different counties from your desk very easily in the course of a day. And also, when you're stuck in court waiting for your case to be called, when you're doing it from your desk, there's a number of other responses that you could take care of. You could respond to emails from clients or to prosecutors. You could get a lot more done because of the nature of appearing remotely. But as remote appearances went away, it suddenly exposed that we were juggling, 6 different flaming chainsaws, and we weren't going to be able to keep that up. And so the inputs were driven into the system and the cracks in the safety net. And then when it really hit the fan when we started going back to in-person appearances, because suddenly I can't be taking these cases in Washington County.
And cases aren't resolving either.
Right. And that's another issue in terms of cases resolving. So I think that's why we've seen the acceleration. But I think a lens that all of our comments need to be viewed as is sort of, even before Ron and I graduated from law school, I think that indigent defense and even maybe criminal defense has been viewed at best with, benign neglect, and at worst with deliberate indifference. That there are people in the system of government and in the system that view what defense attorneys do as a gimmick, as a roadblock, as a impediment to, we all know people are guilty. And that the people that need our services, unfortunately, like many of the populations that need to take advantage of our safety nets, they are others. And that is a problem broader than the criminal system, the otherness of our fellow citizens, of our fellow humans. And when it's easy to think of those are others, those aren't people like us, those are people, I'll never be in that situation, my family won't be in that situation, that I think it explains the context of how we had a system where a constitutional right, from 1790, whatever, was, yeah, come on down and get on the list. Because they became judges and went to law school in that environment. So it's just that culture makes it difficult for the commission to get traction they had direct contact with the Judiciary Committee, but there was some inertia there to overcome. But then with the committees in the governor's office, where they don't have regular interactions with, just falling on deaf ears and appropriations and in other decision makers. So I think it's important that sort of headwind still exists and is sort of influenced all the different factors that people have discussed so far.
So I just wanted to add to something that Rob said, and Josh, you led with some horrifying numbers about the number of people who are not represented correctly. A number that keeps coming up for me is that the judicial system, is holding on in the criminal side to more than 5,000 additional cases than we had in December 2019. More than 5,000 cases. A significant part of that, I think maybe 3,000 are felonies. Okay, so let's just assume most, if not all of those, require counsel. Somehow, I don't know how we've done it, the defense bar, such as it exists now, has been able to represent, I guess, 4,000 of those cases, take on still those 4,000 extra cases. The system just keeps expanding and we keep increasing capacity. And unfortunately, there is a limit. And I think that's where this number has been increasing exponentially over the past year. We should not have a backlog in almost 2025. It's horrifying that we do. Having more counsel is not the solution. And I'm sure other people will speak on that. Solution is getting rid of horrible old cases.
Right. Yeah. I mean, that's something I wanted to ask you all about is, there essentially is a supply and demand problem here, right? There's a demand created by criminal cases and there's a supply of defense attorneys. Or feel free to disagree. But what I was going to say is I think a lot of the dialogue is about increasing the supply of defense attorneys and not so much about changing the number of cases. And what I guess I wanted to hear from all of you about, are there ways in which we can reduce the number of cases, without, I think some members of the public would say, well, you're just not, people are going to commit crimes
Yes.
and get away with it. And I wanted to hear.
Yes, because that's the
you're-
biggest injustice. Somebody might get away with a theft, a shoplifting case.
Right.
That is
So-
the injustice of the century.
So I'll throw something out. Maybe you go back to docket call day and get rid of the dispositional conference.
But
Well,
But they won't do it. But back when I was a boy, right?
it's not the process that's
but-
broken, Ron. It's
but-
not the process. It's
It
the
used-
decision makers.
But
who
it
are
used to
broken.
force the decision makers to make a decision. Because on
Hmm.
Thursday, they'd have to decide what they were gonna try on Monday or Tuesday. And they would force them to make a decision. Before we had the unified docket and you'd go to district court
Mhm.
and you'd file your motion to discuss if you were in southern Maine. In northern Maine, they didn't. It was Rule 22, was it?
Why are you
What?
asking me? I'm not that old.
Okay.
Don't ask me, I'm dyslexic.
But you'd file a motion to suppress. They were called motions to discuss. You go to district court. And you'd also file your jury trial request. So you'd file JTR and you'd withdraw your motion if you didn't get what you wanted in district court and go up to Superior Court where you have to put more pressure on the system. It would force decisions by prosecutors.
Here's the problem.
Go
A
ahead.
significant majority of prosecutors in the state have never tried a real case. And I'll tell you what, a significant majority of younger defense attorneys or newer defense attorneys also haven't tried a real case. They don't know what a case is worth. They don't know issues. They don't know how to litigate the dispositive stuff. It's a huge problem. That being said, I'm not letting judges off the hook. And I'm not letting legislators off the hook. Speedy trial, joke. The bill that was discussed was gutted. There's no speedy trial right in Maine. Let's be for real. And judges have 48B, Rule 48B, I do know that one. And they could dismiss things for delays, unreasonable delays. And ain't 4 years an unreasonable delay. Ain't a year an unreasonable delay on a misdemeanor. So these are the decision makers. They're not making any decisions except to do nothing.
And-
Josh,
And
yeah.
can
No,
I
no,
just say
no, you can't.
Just one
No,
thing.
no, okay.
All right. Just
Only I get to
One-
talk over.
one thing is part of the problem also, remember, is that a unified spokesperson for the bar, the defense bar, I mean, is missing. What I mean by that is when the prosecutors meet with the judges, there's not necessarily a chief public defender in the room discussing something as part of that three-legged stool. And that, I think, is a significant problem as well. It's too dispersed. There's no concerted effort to file. Everybody files the same motion for speedy trial, right? It's just, there's just not that. That's the advantage, I think. Go ahead.
I think that we're the problem.
Where the problem?
We're the problem.
Who's we? Define your term.
That you have three lawyers sitting here. The question you asked about, what can we do about the inputs to the system, the number of cases in the system that doesn't cause non-lawyers, the rest of society, including lawyers, to be freaked out and worried about the consequences of it. We need to have a discussion, and I think a chief public defender is a key part of that in terms of not just lawyering, but having a discussion in our society that is broader about what are the problems and causes of cases ending up in the criminal system. And as a society, what resources do we want to bring to bear to solve them, and in what arenas? A homeless alcoholic individual with mental health issues, I can't imagine that a cross-section of our society that sat down and had a series of discussion and got information from experts and other stakeholders would decide, no, we're just going to arrest them, throw them in jail, and then charge them for drinking in public or whatever, and then give them a little bit of jail sentence and send them on their way. Like, no, that as a way to address an issue. And that's just one tiny little one. I can't imagine our society would decide that's what we're going to do. That makes sense. And the issue is we don't have an ability yet, or in a form, in a to have that conversation so that as a society, we can make the decisions of, somebody, kidnapping people and burning down buildings. That's these cases we want addressed in the criminal system. And someone who's suffering from a disease, we want to give them the counseling and the medicine and the treatment that they need, or the services that we believe as a society are in place in this safety net to address the issues, not just charge them and dump them into a criminal system that doesn't have the resources or the ability or the knowledge and expertise to address the issues. So I think that that's what I mean by where the problem is, that we aren't a bigger cross-section of society talking about how we want to do this. Because I think that there are so many cases that don't need to be in our system and could safely not be in our system. And if we took those resources and addressed the issues that led to the conduct that people are worried about, we would achieve more improvement for the clients and for society. So
Sort of in that same vein, I'm wondering, not having a lawyer obviously hurts your sort of case in all these different ways. But I guess I'm sort of wondering, I don't know what you would say to someone who said, well, they didn't have a lawyer for a month, but they got a lawyer, so in the end it was fine. And I guess I'm just sort of wondering what, along that way you're talking about, like the sort of non-legal sort of wraparound way in which defense is practiced, that it matters that you get a lawyer right away. Bad framing of that question.
I'll just pick that up very quickly.
Yeah.
Just because I represented, I did criminal work in a private law firm.
Right.
So I did work for people often with means who had never encountered the justice system. And that's the way you talk to people, because all of those people wanted a lawyer immediately, wanted to get out of jail immediately. And when sitting in court, thought, what the hell is this? What's this system? This is weird. Why do I have to sit here for 4 hours or 5 hours or 6 hours or all day, right? Waiting for my case to be handled. That's the way I think you talk to people is, do you want your son or daughter to be mistakenly accused? Let's just use that hypothetical and have them sit. What would you think about that? Would you walk into court? And when everybody's being sworn in, all the new attorneys are being sworn in and say, hey, one of you who's really passionate about criminal defense, would you represent my son who's been charged with domestic violence by his girlfriend that I think she's lying? They'd all say no. I think that's the way. I know Rob wants to fix society, but I think you just, within this system, you have to really fight the government and put them to the test, because I don't know that we're going to solve human nature's desire to separate themselves from others unless you try to make them somehow relate in their own world to that situation.
If we just magically upped pay for lawyers, for indigent defense lawyers, to say $300 an hour tomorrow or $400 an hour, does that solve anything? Do we bring people into
we have a bigger bathtub. What I mean by that is this: imagine that the criminal system is a bathtub, and water is pouring into it, right? And there's only so much draining it at a certain size, and water is pouring into it, pouring into it, pouring into it. And different players may be a pension, a spoiled child splashing the water and getting it to, splash out when it's not at capacity, maybe not. But the water is just pouring in, and it's overflowing. And adding more lawyers just says, if you look at that problem, not pull the drain so we can get cases out of here, not turn the faucet down so that it's not filling up faster. It's, we need more bathtub. No one looks at that problem and their first reaction is, we just need a bigger bathtub. But that essentially is what, when people keep talking about the number of attorneys, That's what we're talking about, is not looking at the inputs, not looking at how the system flows in terms of cases being resolved justly and quickly, but rather we just need a bigger holding tank. And so upping the pay, if it were to, get more attorneys in doing a good job and being involved, really is just putting some sandbags on the side of the tub until it overflows again.
Right.
And is that the best use of our money if there's a better way to reduce the amount of water coming into that tub?
So my mother did not raise a fool. I am not going to argue against an increase in pay. $300, sure. I think my private rate right now is $350 or $400. If they want to pay me more money, who am I to say no? Okay. Here's the thing. We went up to 150 and I think March of 2023, and I see Jim back there. You can correct me for all the things I'm saying wrong, but I think there was a misapprehension in the legislature and in the public. Oh, they got more money. Why isn't the problem fixed? Because there were so many other issues for why people are either not doing the work or whatever. But I also think a metric that's never been studied is, what did that increase in pay do for the people who were on the cusp of leaving, like done, versus staying on? It kept more of us in the system, okay? Is it the cure-all, an increase in pay? No. It's just adding more attorneys the solution to all problems? Absolutely not. If anyone wants to give me more money, they're welcome to it. I think especially for the higher level cases, that would make a lot of sense. But no, money doesn't fix all the problems in the commission, but it doesn't hurt either.
And I think that there's the opportunities to examine how can more resources be brought to bear even within our system, not just more attorneys. For example, starting this summer, we're going to be the recipients of a grant where we're going to have a client advocate in our office, one of the first in the state. And that will, not an attorney, but that will allow our attorneys to do better work, and all else being equal, to take slightly more cases, because some of the work in terms of prepping some mitigation or negotiating information that isn't, you need to be a lawyer to get this document or to get these records or to get this information from the client, is being done by someone who's better trained to do it, freeing up the attorneys to do work that supposedly you need to be an attorney to do. And I say supposedly because since our system only pays for the attorney and nothing else, we do everything in the office. But that's just one example of there may be more resources that can be brought into the system that can help assign counsel do better jobs and to be able to maybe take slightly more cases. And really, another voice that we don't have here, and it's not frequently missing, it's almost entirely missing, is the clients. What's it like to be a recipient of legal services in Maine? And I know it varies, good experiences, bad experiences, and perceived bad experiences from excellent work, et cetera, et cetera. But I have found that even after all these years, I still am learning things I had no idea of how it impacts clients. And you mentioned, what's the big deal with getting an attorney? They got one after a month or 2 months or whatever. Well, let's just put you up at a hotel where you can't leave it and you can't make any calls or access the internet, and tell me what falls apart in your life after 3 weeks.
How are people not burning down?
And you've got a
jail?
job and savings and everything. If
Yeah.
if you're already at the edge and suddenly disruption like that happens, the impact on individuals in terms of losing those safety nets that leads to, statistically speaking, more involvement in the system is profound. And so that's some of the impact, but just many of these cases have implications, even if they're not in jail, that are ripping their lives apart in terms of bail restrictions, or just the stress of what's going to happen to me, or even losing their driver's license when maybe that could be avoided. You know, I went up to Aroostook County for the second time in my life in September and went all the way up to Fort Kent and was able to appreciate the fact that it is the geographic size of Rhode Island and Connecticut combined. And we have laws in our books that take away people's licenses for all sorts of things that don't involve dangerousness in driving. The impact that that has on individuals and then them just never getting off the conveyor belt of being in the system is tremendous. And so I think it is a huge impact on people's lives, even if they're not in custody, without a lawyer to guide them. And also without a lawyer that is doing the absolute best for that client and meeting with them ahead of time, investigating, working up the mitigation to, yeah, I know they were suspended, but here's the thing. They've got 3 kids, 2 of which are special needs, and they got to get into disappointments, and this is what's going to happen to their license. Can't we do a filing or something that doesn't result in breaking that chain? Not everybody gets that, and they should.
Can I just ask, from these two, is there a problem, you think, in the way that prosecutors are being trained? Or is it just an attitude?
There are people who lead prosecutors' offices in this state who I don't think know the law, rules of ethics, nothing. And they're the ones responsible for supervising line prosecutors who have people's lives in their hands. So yeah, it's an absence of training, absence of experience, lack of accountability. It's all 3.
So it goes to the issue of power. Melzar, professor at the Maine Law School, he's taught criminal law. One of his things, he was always talking to the future prosecutors because of the power they had and how they used it shouldn't use it responsibly. And in my experience, I had prosecutors use it responsibly. I don't know.
What's one of the things that's interesting, if you talk about power, you've got the state of Maine, which is responsible for providing counsel to these individuals. And that's who the prosecutors represent. And the prosecutors, though, face no limits on their ability to bring cases. They bring cases without any regard to the ability of their client to staff them. And it's just, it's interesting that the powers that be put no check on them and say, you know, listen, you can bring as many cases of whatever type you want that you can staff, for example. That concept is viewed as ridiculous and absurd, but their client controls and is responsible, controls how much resources are put in and in what method, and controls what discretion is authorized. This crisis is going on, and yet they are still charging shoplifting as felonies from big box stores. How do you, as a prosecutor, square this shoplifting from Walmart is so important? I'm going to charge it as a felony, implicating the right to counsel, despite the fact that there are no attorneys to staff domestic violence cases and child sex cases. What goes into that calculation other than I have nothing to do with it and it got nothing to do with my decision making? No one is holding them accountable. And I think that isn't just the prosecutors, because nobody's holding them accountable. Like we file motions, we make arguments about the 6th Amendment. There is nothing that is happening from any other decision makers that causes them to change their behavior and exercising their discretion. Additionally, data, the information that's out there. How many people have pled guilty after they have been found indigent in having a right to counsel, but yet before counsel was eventually assigned? I don't know. Nobody knows. The judicial branch doesn't track that data. Their current database and probably their future one doesn't have fields that would allow for that data to be tracked. Why? Why would they design a database where you wouldn't be able to check, run a search for, right to counsel found, and then be able to search for null or whatever the database equivalent is for attorney assigned, and that the case is resolved by a guilty plea? It should be an easy thing to track. And remember, when I talked about benign neglect at best, what caused me to either snap or go on this crusade was when back in 2000 and 2006, beginning of 2007, the judicial branch was facing that budgetary crisis. You know, there's a balanced budget requirement. So they had to come up with a plan to balance their budget, holding judge positions open and clerks positions open. You know, they had to have a plan. And part of their plan was for 6 months, the last 6 months of the fiscal year, if you were an adult and were going into court but weren't in custody, they did away with the lawyer of the day program for 6 months. You would go into court, there'd be no defense attorney there. And I bet if you look back at that 6 months and got the data as to how many cases pled guilty, and then looked at those cases and figured out how many of those were at first appearance, you would see hundreds and hundreds of cases that the judicial branch had no problem taking guilty pleas at initial appearance, even though there were no lawyers of the day. And these aren't evil people. This is just the way it had been.
Yeah.
There was nobody out there pointing out the problems with the cases. And previously, there was no one for them to consult in that decision. When I talk about, and Ron talks about the chief public defender, if we had had a chief public defender, when that plan was announced, I'm pretty sure she would have had something to say about it in terms of what the implication of that would be. But it was a vacuum when it happened. So that's a lot of the issue, is that there's a lot that's out there that we don't know about, that we can't access it. And it's not, I'm told, easily accessible in terms of the data. But it seemed, if we were that concerned as a society as to the issues that were being caused, then I can't imagine that there wouldn't be a way where this sort of information was being tracked and accessible so that we could quantify the issue. And we, as a society, would be holding the decision makers of the gatekeepers of cases coming into the system accountable to, you got to match the ability of your client, the state of Maine, to staff it. We're not telling you which cases. We want you to make good, sound prosecutorial discretion as to priority and safety of the community and in the individuals. But yet, shoplifting from Walmart, it's a felony because they've had in the last 10 years, they had 2 other thefts. So we're just charging it as a felon. How is that? What's the calculus that led to it?
What responsibility do judges have then to be like,
A lot.
Yeah.
you know, why are you bringing this?
But-
You have
but-
to match it.
And part of it, this is a resource issue too. Anybody who goes into federal court, right, knows that the process is so much different than in state court. And you can have to appear in front of a judge in federal court in chambers conference and explain and have the prosecutor explain just how he's going to meet the elements of the crime. The judge will actually, you know, might actually take that serious a look at it. Is this really the right charge? That doesn't happen in state court. You can stand in state court, and this is a real example, is see someone plead guilty at initial appearance to shoplifting a bottle of Advil, 70-year-old man, and the fine is $250, that he's going to pay $10 a month. And the judge doesn't say, I'm sorry, this is ridiculous. You're not doing that. With $250, $10 a month. No. Or I've witnessed a defendant argue bail better than his lawyer. Lawyer's standing next to him, doesn't say anything. The defendant starts arguing bail. Judge doesn't take that lawyer back in the chambers and to the woodshed. In federal court, I've watched people get reamed out.
You get
in
pulled off the
public.
panel. You
Yeah,
get pulled off the panel.
But you get reamed publicly.
Yeah, that too. But I mean, we
I
pulled their
sat
ticket.
there watching someone get reamed out as I played with my pen. I mean, you know, and tried to, you know, not pay attention. But so it's sort of a resource and pay attention, and how serious is this kind of thing? So I have a lot of respect for our judges. I do, but go ahead.
No, I think the problem that I was stating with the newer attorneys, prosecutors, even some with significant experience, and honestly, I know some defense attorneys who have been doing this almost 10 years, never had a trial. it flows up to the judges we have in Maine, the state court judges. So many of them have not presided over many trials. They didn't do many trials as long. They don't know what a case is worth. They don't think it's their place to push the prosecutors on what a case is worth and why the hell are we here. They don't see it as their role. When we have a few judges who do see that as their role, we get things resolved. But that's not expected, it's not encouraged, and I don't know if there's some policy that's floating out there now in the judicial branch that you don't want to push anyone too hard in these conferences. But the judges, regardless of the dispositional conferences, again, I know most of you are lawyers in here or lawyer adjacent. Judges have Rule 48B, the power to dismiss. And if the state of Maine's prosecutors want to appeal every dismissal under 48B, have fun when you can't even keep up with the cases you have. They're so choking on the shoplifting felonies. I would say even more so the possession felonies. You have less than a gram of any junk on you and you're a felon. They're drowning in those cases. They're eating SHIT in bigger cases because they don't have the time or the resources to actually try those cases properly. The cases, I don't know, that matter with real life human victims possibly. When you're a prosecutor, and I was a prosecutor many, many moons ago, when you are just trying to make it through the day and handle your caseload, and you don't feel like you can prioritize things, you're not going to be expending the resources properly in a way that actually promotes public safety and any respect of the system.
Oh, sorry. Yeah. Are you done?
I am now.
Oh, sorry.
Let's talk about judges.
Yeah.
Go ahead.
So there are times when members of the judicial branch view advocacy as a problem. Now everybody accepts that there's a crisis, and the fact there isn't counsel to assign is a serious issue, and we have an order from the trial chiefs that every 7 days, if you're in custody, you're going to be reviewed.
Right.
A month and a half before that order was issued, I was filing motions like crazy as lawyer of the day in Bangor, in Penobscot County. And on a hearing, which were all denied as to the right to counsel, they wouldn't be set up for a hearing. And in response to that, the court then assigned me to cases in Bangor that I had filed motions on, because that made sense. And in a hearing in one of those motions, the judge said, when I was again arguing the issue of the Sixth Amendment and the right to counsel, that was chastising me for not taking cases, and then accused me of putting the cause before the client by filing these motions. And, that sort of attitude certainly doesn't encourage individuals to address the issue and to bring it to light, unless you're me, and then it just gets you fired up, and even more because that's the way I'm wired. But that happened. And there are many members of the judicial branch that are supportive and believe wholeheartedly that we are doing our job as advocates, and find that admirable, and appropriately, as judicial actors, encourage good advocacy on both sides. That don't get me wrong, that exists a lot. But there's a transcript out there that you can order where the judge is saying that, and that's rather shocking. So there is more that every actor can do in the system. The more that prosecutors can do, there's more the defense bar can do, there's more that the judges can do, there's more the legislature can do, and I think there's more that citizens can do, all of us, to talk about this issue, learn about the issue, and discuss it with those that make the decision, and make the decision that this is important, and it shouldn't get short shrift or short funded.
I'm gonna jump to audience questions in a second, but I guess finally I just wanted to ask you all what, how long does somebody have to be without a lawyer to have it be a Sixth Amendment violation? Doesn't seem like in Maine we have a specific sort of rubric for that. In Oregon, it's the 7 days you're out of jail, according to that ruling. And yeah, I don't know if a Sixth if somebody doesn't have a right to an attorney in a certain period of time, then is Maine even upholding the Sixth Amendment? And, you know, we're basically saying like, there's public safety. I think these hearings I've heard that they're saying, well, it's a Sixth Amendment violation, but public safety is also something we have to weigh. And I guess I just wonder, you know, is that the right legal analysis? When should Sixth Amendment cases, I mean, when should these cases just be dismissed on Sixth Amendment grounds?
So a right doesn't really exist if there's no remedy for the violation of that right. What we're seeing, and Rob, correct me if I'm wrong, but we're seeing orders where judges will check the box. Sixth Amendment violation found. See you in 7 days. There's no remedy. They don't give a remedy. We had a judge try to do that and all hell broke loose. It's like literally the worst case scenario.
Right, Judge Churchill with Ian Hinckley
Right.
in Auburn. Yeah.
Right, but I don't care that judges are finding a violation if there's no remedy for the violation found. So Oregon made a across the board decision, 7 days. Guess what? If the remedy was dismissal, maybe the prosecutors would have to dismiss the stupid cases to ensure the people with the serious cases get counsel because we're tapped out. We can't take on more. Maybe it would actually force their hand to triage. And I'm sorry I'm always dogging on prosecutors. I just know from working in the system so long, they really do hold all the power. Realistically, they hold all the power. And I take that very seriously. So when judges are checking a box to say your constitutional rights been violated, so sorry, we'll see you soon, unacceptable.
So as a defendant in the ACLU's lawsuit at one point, with
What's going on with you?
with my email memo attached as an exhibit to that complaint,
Mm.
I would have admitted to the violations. I would have conceded that if I had the power to do that, we were nominal defendants.
Mhm.
But I think that I agree with Tina that it's nuts. And I've actually watched. So I've gone on. So I'm no longer in private practice, but I've gone on to the link and watched some of these 7-day reviews from my office, and
Yeah, same.
it's pretty depressing.
So what I think the case law, which is not very good and was not developed when there was this sort of crisis in place, talks about a reasonable time to provide counsel. And again, it hasn't really been tested in a systemic, ongoing inability to provide counsel scenario. And former executive director Justin Andrus, who's not here today, so I can say he said whatever, one time asked me about, well, Rob, that same question. When do you think there's a violation of the Sixth Amendment? And my answer to him was, do we have a situation where we don't know who the attorney is yet, or we know that we don't have an attorney to assign? If the answer is, we know that there is no attorney to assign, then it's a Sixth Amendment violation after it attaches. Because we could find, and we are stating in that hypothetical, there is no attorney to assign. And if the system has brought so many cases where it gets to that point, it's a Sixth Amendment violation. The remedy, though, for it depends on a number of factors, including the amount of time. So, that's a reality. But if there's an inability to meet the state's obligation once it has attached, as opposed to bureaucratic administrative determining which attorney in the public defender's office, which attorney in a different place, it's a violation. And the system and the players pretend that it's not. Another argument would be, well, clearly it must be at 7 days, because the trial chiefs would not have suggested that an individual in custody needs to be seen within 7 days when the system's already overburdened with too many events and not enough court time, creating an entirely new event at which bail shall be addressed. If they didn't think that 7 days was unreasonable, they weren't doing it for shits and giggles. Though the prosecution, time and time again, we disagree that there's been a Sixth Amendment violation, that it has not been an unreasonable amount of time. I have seen them argue it and the court find that. When the person was in custody longer than the jail sentence that the state was seeking on a misdemeanor. How the heck is that not an unreasonable amount of time? If they're looking for an 8-day sentence and you've been in for 14 without an attorney, 14 days since the right to counsel attachment was ordered, how is that not unreasonable? But the court did, no, not unreasonable, no Sixth Amendment violation. So again, in the bright line rule that I put out there or think about is, if it's an impossibility, we know that we have used up our available resources of attorneys to staff these cases, then it's a violation if we're bringing more cases. That's my opinion. But that doesn't answer the question, because then what's the remedy? Are you in custody or not? How much time has gone by? I think that, the suggestion to say, you can only bring as many cases as there are attorneys to staff them, choose your cases wisely, puts the discretion into the elected DAs, and they can make the decision and prioritize them and not have cases dismissed or bail lowered for the people that they believe it shouldn't be. Again, there's a lot of arbitrary power there, but they're not even held to account to that. They just make their decisions, argue there's no violation, dare the court to do anything. And remember, yeah, there's the high profile thing of a case going wrong in an individual, not a case going wrong, an individual going wrong after they received a proper result. But what's the difference then? Would we say, well, what was that jury thinking, finding him that it hadn't been proved beyond a reasonable doubt because he got out? And then he went home and then he went over there and caused a fire and killed a person and everything. That jury, we got to get rid of the jury system. How dare they find someone not guilty? How dare they find that the state hadn't met its burden beyond a reasonable doubt? It's the equivalent. Her reasoning wasn't wrong. I think a lot of questions should be asked with what the state actually did after the ruling, besides just complain. Did they actually, have a cruiser sit outside his place and see he had house arrest? He could have been arrested.
No, zero.
Right. But the thing is that you look at her decision, there's nothing wrong in that decision, in the logic to it.
Yeah.
Anyway, sorry.
I think we have time for some audience questions. Do we have mics, I believe? Yeah. Thank you, Emily. Does anyone have any questions? Okay. Right here.
Hey, my name's Grace. I'm a third-year law student, and I have watched a lot of these 7-day reviews over the last few months. So I'm an intern for the ACLU currently, but I'm asking on myself, not on behalf of them, just to clarify. But so I think that what I've seen is that you're absolutely correct, is that you see Sixth Amendment violations rolled on and then defendants staying in custody for a very long time, sometimes, like another month before they're getting representation. And I think the issue is that the law is pretty unclear. From my understanding, the Supreme Court, there's like the guidance is there's like what is an unreasonable delay, and then what is what's the other prong that I'm thinking of? Sorry, it escapes me at this moment. I was just thinking about it. But like the law court doesn't know what to do. Oh, sorry, critical stage. So critical stage, unreasonable delay. And that's the big debate. What is a critical stage? What is an unreasonable delay? And the law court hasn't given us any guidance. So the district court judges, I'm seeing them out there saying this, we have no guidance from the law court. What are we going to do? And so you're getting all these different like rulings that, one judge is saying, yes, this is a critical stage, and one saying, no, it's not. And I think there's a lot of hesitancy from the decision makers because they have no guidance. And yeah, like you said, they're weighing these like public safety concerns, but it seems like the balancing test like really isn't working. So to me, it seems like a bright line rule, like Bestard in Oregon, like could be a good solution. And I guess my question is kind of if the panelists could clarify what you see as what do you really want to see as a remedy? Do you want to see the law court define these stages? Do you want to have a bright line rule that says that if you don't have an attorney after 7 days, you get released or your case gets dismissed?
Just one thing that's, I think, important to remember is I believe a lot of these people who are sitting in jail, if they had money, they'd be out of jail. So the concept of public safety is really a monetary one and not a real one. If you had the 5,000 or the 10 or the 20 or the $25,000, you would be out of jail and you would be free to go kidnap and kill, right? So this is really an economic, socioeconomic problem and not a public safety problem. And that's part of the mistake when people hide behind, oh, the public safety issue. That's not what it's really about. People aren't sitting in jail for public safety reasons. They're entitled to bail. There's a bail amount and they can't make it.
I totally agree, but I think that the decision makers are hesitant. They couch that in public safety, and because they're afraid of the blowback and the pushback that they would get from the public.
But I mean, one of the things when you become a judge, in my opinion, is you should not care about public sentiment. I remember I was a clerk and I wrote an opinion overturning something that Chief Chitwood was really in favor of. And the judge was excoriated by Chitwood above the fold for the decision. He was very proud of that, that he had pissed off. The judge, sorry. The judge was very proud of the fact that, and happy that, and a little amused that he was getting this world of crap from Chitwood for the correct decision that I had helped him draft. I was proud of it too.
Grace, to your question, I think the law court sidestepped addressing this issue, and Rob was involved with some litigation there where they could have maybe set these bright line rules. I think one thing that could happen, I don't know if it will, is, if somebody's deprived counsel, somebody, I guess we have to do it pro bono, could appeal the lack of imposition of a remedy. And what I think the law court does is call up the trial chiefs and say, hey, we need to get this some attorney so that we can make this moot. I think that's what's being done, frankly. But the law court doesn't have to do that. They can take up things that are facially moot if it's like, it has like public importance. It could be replicated. I mean, obviously it can be replicated. People are without counsel all the time. And then set a bright line rule as the full court. They could do that. I wish I had confidence that they would do that. Oregon, 7 days, sounds good to me. Sounds damn good to me, because it's enough time for the prosecutors to really kind of say, are these cases worth it? What can we do to make sure the most important cases get counsel? And the way we do that is take away the cases that aren't as important. So I would hope the law court could step up. I'm not optimistic about that possibility, unfortunately. I think Rob's less optimistic than I am.
And it is important to know that judges don't receive guidance. So judges are basically their own bosses and are told essentially make your decision the best decision you can. That's why you get all of these different decisions.
Hi, I'm Jeff. I'm also a law student, third year. And as a follow-up, I guess I mean, we don't have an intermediate appeals court. Why haven't there been any challenges to this that the law court would take up?
You'd have to ask, and there's a number of issues, the individual defendants, the appeal process itself. I have found on a number of cases that I've been working in Augusta County remotely for initial appearances for people in custody since February. And two instances that I remember in particular that I had, one, I had filed a notice of appeal for an individual where there was no remedy found after a Sixth Amendment violation. As I recall, a Sixth Amendment violation was found, but no remedy, filed notice of appeal, and then, which now they can't find. And then counsel was assigned the next day. So it sort of became that, his attorney, not just the lawyers of the day, responsibility to make the call. More recently, I teed up a case I asked that a case be specially assigned for a motion to dismiss in front of the judge that found the Sixth Amendment violation. It was going to be heard, in November. I think they were going to do it during October, rather, during the admin week. They were going to do it. And then the next day they found him counsel.
Magic.
So it's difficult to tee up. I think Rory McNamara and Tina may know as well, there's a threshold question of, is it an interlocutory or appeal? And so you can't appeal the issue, or can you in a straight appeal? Obviously, Rory suggested, and we ended up doing last year, a habeas corpus action, which, I got the dogs on the front page of the Press Herald. I'm very proud of that. But, there were many people in the judicial branch that were mad at us for doing it. Members of my firm reported back to me that they were taken aside and said, there's some discussion about that the judicial branch has to recuse itself from your entire firm. This is not a joke. This was what a judge said to members of my firm because of that habeas corpus action, which of course it's like the sheriff in Augusta County volunteered to drive down to an attorney's office to be served. He understood he's just being named in the lawsuit as a placeholder because he's holding people. It's not like he did anything to deprive them of counsel. He was very fine with it and understood the process, but so there's some threshold issues there with getting it reviewed. Not that we haven't tried. I know that Mitch Roberge is trying to work on that issue as well. He primarily deals with the once a week Androscoggin County 7-day equivalent of 7-day reviews. It's got different names, different places.
We have one question from Zoom, and I think we're pretty much out of time here, but this question says, what is the impact of this crisis on victims of violent crimes, such as domestic violence, who argue prosecutors are not prioritizing their safety?
Yeah. When there's one part of the system that doesn't work, it doesn't work for everyone. And of course, my concern as a criminal defense attorney are my clients, but I also live in society and I care about safety. I care about people getting redress and being protected. And it benefits no victim to have a case languish on the vine for years at a time. And it doesn't promote public safety to keep these cases open the way they have been kept open. So, Rob, go ahead.
I did it twice now. You go ahead.
No, you're okay. You go ahead.
Sorry.
We've only been doing this for like 16 years.
Yes. Interestingly, yesterday, Attorney Wilson, one of the attorneys in my office, was in my office, and we received a call from a victim of domestic violence. She had just gotten a protection order I think it was on yesterday, at the docket in Portland, and was back at the shelter with her children and was looking for an attorney to help her going forward. It seemed like what she needed, because she had the protection order now, was an attorney to help on a pro bono basis with the family law case, because there was one child in common, and to disentangle or set up rules for the next 15 years, because I believe he was 3, to deal with that. And the ripple effect of dysfunction in the court system affects all the functioning of the judicial branch in the cases it's supposed to handle, the business court, family law court. And it leads to shortages with, attorneys that are available to volunteer for those sorts of things. Pine Tree Legal may have been conflicted out because of handling something for the defendant once before she had been told. And so there was a woman reaching out to help that needed assistance, and we were struggling, Attorney Wilson and I, to come up with options to refer her to. And part of that was because of the strain in the whole legal system. So the impact affects in direct and indirect ways. The backlog of family law cases, those are very stressful and lead to a lot of conflict. And people that know about domestic violence much better than I do, and I was a domestic violence prosecutor when I first came to Maine, those cases not being able to resolve quickly do not help those situations. That those are situations where getting them resolved by a judicial, an arbitrator or decider, making those decisions and laying down the guidelines are something that is very helpful for people to begin the long process of trying to move forward with boundaries that they can cut ties and protect themselves. I don't pretend to suggest that that's a magic wand and it makes it all better, but certainly that makes things worse. And the backlog in the system that leads to cases being resolved or suboptimal outcomes, or even just the dysfunction into providing notice that so that the individual knew the case was being resolved, and that the defendant, she was going on probation, so that the victim in the case was aware that it was going to be released. Breakdown happens with those communications. And I've had in my career, not recently, the situation where the victim had no idea that my client was getting released, because it's not common, but it can happen. And it's because of the strain on the system. And so it impacts victims in direct and in indirect ways.
Any other questions? Sir.
Sir, microphone.
Interested in your statement about the lack of trial experience of the prosecutors, the defense counsel, and judges. In as much as our system is based upon ascertainment of guilt and responsibility by a trial process, it seems logical that the people who are charged with representing people who are caught up in that system need to have some minimal familiarity with that process and some minimal level of confidence in their ability to make use of it in order to provide effective representation and even effective counsel to somebody as to whether or not they should plead guilty as well. Has anybody been looking into this and considering that this lack of trial ability on part of all three key participants is a problem?
So for once, I won't speak for the prosecutors or the judges here, but I know for the defense bar, I think training is very important. I think we have to basically train our ways out of the problem because there just aren't that many trials, but I think it kind of feeds into itself. The more trials you have, the more confident you are in bringing a case to trial. So one thing I know the commission has done that's been very helpful, will bear fruit, is consistently approving co-counsel for trials, both for newer attorneys who are trying to try low-level cases, they get someone more experienced to be with them, or having experienced counsel get someone with a little less experience to co-counsel on a bigger case. I think that's extraordinarily helpful. I think that's how we double dip and hopefully double the amount of trial experience. It's not a cure-all, but I do see the consequences of this play out every day. I mean, how are you even reviewing discovery effectively if you don't understand the rules of evidence and how things would either be admissible or arguably inadmissible? I think it all goes, I know you know about evidence, so I'm not preaching the choir here, but this is it's a skills problem, it's an experience problem, but I think it comes down to, we need to establish the PD's offices to build in that system support, mentorship, and training to get people in court on their feet doing the work. Because it does all lead to that, at least in theory.
Well, that, just a comment, of course, it's a bit like a spiral, is that the less trial people have, the less they want to go to trial, and it
That's
goes
right.
round and round.
That's right.
And pretty soon, nobody wants a trial, and so they dispose of the cases without too much regard as to what a trial would do.
And I think with the caseload standards, capping the amount of cases somebody might have, particularly for the newer attorneys who used to just take anything, that should give them the space they need, I think, more to engage in trial work, which is all encompassing. I mean, I won't say it's not, but it's worth it. And if you want to do this work, I don't think we got into this job to do please.
Amen.
I think
One of the things that I'm hoping for is that there's hopefully there'll be a student attorney rule that's expanded this summer that will allow law students to participate, not just at the DA's office or public defender offices, but also at offices like ours at the Maine Indigent Defense Center, which would give a number of benefits to the system, getting more people interested in doing the work, but also being able to do actual arguments in court, maybe even some trials like Ron had at the clinic in more places like defender offices or non-traditional defender offices like ours, private attorneys that do indigent defense work. And also Michigan, University of Michigan Law School has a public defender institute that's more like the training centers for that prosecutors have down in Columbia, South Carolina, where it's not a real world experience. It is it is a closed environment where you have members of the public and actors and real expert witnesses come in, and you are taped and reviewed by practitioners that are experienced. It's a year-long program at University of Michigan, and that's something that might get some more nuts and bolts skills into new attorneys when they leave the door, because the clinics are great and should be increased as much as we can, and we should support the capacity for the clinics. But you may not get all the different experiences because it's all about what's best for the clients. It's not, you're not going to do a motion hearing if it's not the best thing for the client. Whereas you can still in this sort of institute, this boot camp, you're going to have a motion problem that you're presented with, and you're going to do it, and it's going to be critiqued. You're going to get feedback by different practitioners. And so those sorts of things can enhance the trial skills. And again, it's invaluable what Jim and the commission and Ellie have approved, the co-counsel on trials, that it's so great that that's an automatic, that if you're going to trial and there's an attorney that can gain from the experience, or even if you just need the second pair of hands and eyes and brain on the trial, the commission is saying yes. And that is absolutely great that they're doing that.
all right. With that, I believe we have to wrap it up. Do we have time for one more? No? Okay, we gotta be quick. Sorry.
Sounds like a great proposal for maybe the law school clinic and externship people to draft an amended bar rule that would allow that. That's all it takes. Some advocacy behind that. I think it's a great idea. Thank you.
All right. Thank you all very much. A round of applause for our panelists, please.
So hi, everyone. Thank you for being here today. I'm Stephanie McFeeters. I'm the deputy editor at the Maine Monitor. I've had the privilege of working with Josh on all of his reporting on the indigent defense crisis and on the new build out of the public defender network. So it's great to be in the room with everyone here today and put some faces to names that I've spell checked many times. And, just to talk about what's clearly a very important issue. As journalists, we're often the ones having these conversations and then trying to synthesize them and put them to paper. And it's really nice to just sort of have that free flowing conversation that we're having here today, where everyone can sort of participate in asking the questions and sort of talking them through rather than just seeing it static on the page. And like Josh, I didn't go to law school, although my parents keep telling me it's not too late. So, I've told them I'm sticking with journalism till the presses stop, but we'll see. But I'm excited for the crash course today. So we just heard about the crisis here in Maine and how we got here. And before we get to the steps that are being taken to address it, which Josh is going to get to in the next panel, we're going to pause and look at what's going on elsewhere. There's a tendency in the media, and I think just in life, to see things as, to focus on the negatives, to focus on the bad things, and to see them as uniquely bad. And at the Monitor, we try to resist this myopia when we can. And it's something that Josh is very good at thinking about, and all of our reporters are good at thinking about, which is, is this a problem elsewhere? And if so, what's being done about it? So for this panel, we're going to zoom out. And the goal is to expand our lens a bit and to think about the opportunities that exist as Maine begins building out its new public defender network. What lessons can we take from other states, both good and bad? And the idea here is to focus on our neighbors in New England, but of course we can go broader than that. Oregon came up, and I'm sure that'll be useful for us to discuss. But the whole idea is to ask, what's working, what isn't, and what can Maine learn from that? And as with the first panel, we'll have a decent chunk of time reserved for audience questions at the end. So we'd love for you to think of those and hold on to those. And if you're in the Zoom, you can put those in the chat. So before we dive in, I want to make sure we get to know our panelists who have, traveled from near and far to get here. So I would love for you all to, tell us a bit about who you are, what you do, and how you got into this work, because I think having that perspective will be useful as we have this conversation. So David, can you start us off?
Certainly. There, that's better. Thank you, Stephanie. My name is David Carroll. I'm the executive director of the Sixth Amendment Center. We're a nonpartisan, nonprofit organization out of Boston that works with policymakers across the country to improve indigent defense systems. We do this mostly through evaluation and then providing technical assistance. We often talk about ourselves as like home inspectors that come into systems that have been inherited by the policymakers for indigent defense. We, look behind the walls, we check the foundation, and we point out where there are deficiencies, and then work with the policymakers to try to fix those deficiencies. The Sixth Amendment Center is a little over a decade old. I have been doing indigent defense reform in one form or another for about 30 years. In that time, I've traveled all across the country. Most recently going to Hawaii, not on work, but I've now been to every state, and in almost all those states looked at some portion of their indigent defense system. In 2019, we published a report on Maine's indigent defense system as it stood at that time. We did a deep dive into 5 of the counties as a representative sample. We did not choose those counties. We had a group of policymakers that were asking us where to go and do things. we found a number of very problematic issues that we were hoping to resolve. We can get into some of that and how it compares to other states. But that's who we are. I want to point out our Deputy Director, Aditi Goyal, in the back. So if you have questions at lunch, if one of the two of us can certainly help you with all of those. I look forward to the discussion today.
Kyle, can you take it next?
So my name is Kyle Robitis. I'm the Director of Professional Development at the New Hampshire Public Defender's Office. I've been in the administration in New Hampshire for a little over 2 years now. Prior to that, I was a staff attorney in the Manchester office, which is our biggest trial office. Originally got into public defense because, much like probably many of you, I did a ton of volunteer work and fell in love with the client population, got into public defense and realized that the culture and community that exists in the public defender's office is an even bigger pull for me because it's such a great group of people. And so now I've been doing this for over a decade.
Great. And Daniel, we'll go to you.
Thank you, Stephanie. First of all, my apologies for not being there in person. I'm here in Boston. Unfortunately, I have a lot of commitments here. I am a law professor at Northeastern University, where I specialize in criminal law. I'm a former public defender at the Legal Aid Society in New York, and I come from a long line of Maine lawyers. Some of you in the room may know my late cousin, Marshall Stern, who died many years ago, but was a criminal defense lawyer in Portland. And some of my relatives were lawyers up in Bangor as well. So I'm especially interested in this project, and I'm very grateful, Stephanie and Emily, for the invitation.
Great, thank you. So Dave, I was hoping you could start us off with a sort of brief overview, a state of the union. How would you describe the overall health of the, indigent defense system across the U.S. and what are some of the big challenges and debates and reform efforts that you're paying attention to?
Certainly. Indigent defense in the United States still is very problematic. What I do want to not lose sight of is over my 30-year career, there have been great strides in improving indigent defense all across the country. We have many more statewide commissions that have the authority to oversee and administer indigent defense services. More and more states are picking up a bigger chunk of the cost of doing it, and more investment is being put in. Is it enough? No. And it's not enough for some of the reasons we've heard from the first panel, is if you're just putting money into a system to try to keep up with what's going on with prosecution, you're always going to be behind. So some of the things that we see across the country is incredibly high caseloads for public defenders. This has been a lot of advancements in technology. What it takes to handle a case takes much more time because of the number of ring cams that are around, for instance, and the digital media that has to be reviewed in many of the serious cases. But what I do want to say in pertinent to Maine is when you look at the crisis that is occurring with the lack of representation going on, when you talk about that problem, people always say, well, it's a problem nationally. You've got Oregon and you've got Maine. But those are really the two problem spots right now on that. Is it any other states going on with some lack of counsel? Certainly, but not to the degree that we're seeing in those two states. And I think one of the common elements is that those were the two states that always traditionally try to provide indigent defense through private attorneys and private bar. That's not to say, and I want to be very clear about this, that public defenders in and of themselves provide better representation than the criminal bar. It's not true. You can have very good private bar systems. My home state of Massachusetts is one that does a lot of representation through that. What we're saying, though, is that public defenders provide some things that we're hearing is needed in Maine and what was talked about in the first panel. So for instance, with the pandemic, we did see a lot of older attorneys say, okay, I don't want to be in jails anymore. I'm not going to practice for health reasons. We didn't see the younger generation come in to fill that gap. And what we're hearing nationally and what we're seeing nationally is that what the young attorneys want is work-life balance. They want to have a system where they know that they are going to be getting benefits, that they're going to be getting pensions, that they're going to be getting mentorship, that they're going to be getting supervision, that they're going to be getting things that are not available if you're just trying to hang up your shingle. And so the systems that have public defenders and are paying them well are the ones that are hiring lots of attorneys. Aditi just reminded me earlier, the state of New Jersey just hired a class of 60 new attorneys into their system because they have the structure and ability to do that. In our report, one of the things we recommended that was not done, despite many of the other things being attempted and done, is that idea of a public defender office should be placed in Cumberland County or one that handles Cumberland and New York, because we think having a system like that would have attracted the younger attorneys that you may not be getting into the system now. You can draw from the other New England states if there were the ability for young people to have that sort of work-life balance that they're looking for. So that's sort of my opening salvo, I guess.
Well, you touched on what my next question was going to be, which was, I think, a lot of people in the room are lawyers or lawyer adjacent, as someone said earlier, but not all of us are, not everyone on Zoom is. So before we look at some of these specific states, I thought it would be useful for us to sort of take a step back and just understand what the different ways are that states could choose to run a public defense system. So I understand, they're public defenders who are government employees, sort of the same way prosecutors are, they're contract attorneys, and then there are these hybrid systems. What sort of are the options there, and what are sort of the best practice? What's the best practice right now?
So that's really the full length of it. You either have private attorneys paid hourly or under contract, or you have staffed government attorneys that are doing it. And then it's what percentage is handled by what at that point. And, there is a set of national standards called the ABA 10 principles. And it says that if the workload can support a public defender office, then you should have a public defender office. That was the basis of our decision to recommend that Cumberland County be the first place for a public defender office in the state of Maine, and potentially one that could cover York as well. I think it's great that things are moving forward in Kennebec County and the roving public defenders in the north. But we were trying to follow ABA guidelines specifically in making our recommendations to Maine. And I think that's one of the things that sort of, when the pandemic hit, not having been on that path has caused some of these crises to come into being. As we mentioned, Oregon was the other state that relied exclusively on private bar. They had some nonprofit public defenders under contract, but what we find is nonprofits under contract can't do the same sort of benefits that state government employees can. I know we'll hear from New Hampshire later. We did an assessment of New Hampshire too, and that was one of our concerns of, can you draw people into the system, not giving them the benefits that they would get from a state government employee position? I do want to say Oregon's a little bit further ahead than Maine. And so the things they've been moving to open public defenders in more populous counties to be able to do that. They're moving towards an hourly rate, getting rid of contracts. Their hourly rate is also around $150 an hour on cases. But that plus what you heard from the first panel about that decision about cases going without counsel after 7 days, we're seeing those numbers dropping now in Oregon. We're going to see that come. So I think Maine is going to be very isolated very soon on that particular issue.
Well, I want to get into the, what the system in New Hampshire looks like and what it looks like in Massachusetts. But before we dive into that, we got at this a little bit in the first panel, but, Rob was saying that the client's voice is often missing. And so I wanted to take a moment to kind of get at the stakes here. We're talking about setting up a system where everyone, regardless of their ability to pay, gets access to a lawyer. And so, Daniel, I was going to turn to you and just ask if you could sort of paint a picture for us of what it means when someone doesn't have representation or, when there's a delay. What does that look like?
Great. Thank you, Stephanie. Can people hear me? I heard that there was some muffling. Let me know if there's a problem and I will shed my headphones.
It's much better now.
Much better. Thank you very much. So Stephanie, first of all, I really like what you said at the beginning. Sometimes in situations like this, we tend to focus on the negative, the doom and gloom. I think this is an opportunity for us to make lemonade out of lemons. One benefit about being the last state to consider an institutional public defender is we can learn lessons from other states. And you have the advantage in Maine of having an excellent bar that is committed to zealous advocacy, a beautiful location that's attractive potentially to young lawyers, and you have a commission that has 15 years of experience in some type of supervisory capacity. So there are a lot of benefits. As to your question, Stephanie, if you think about, and I realize you mentioned that there are many non-lawyers in the room, if you think about the criminal defense lawyer as the last line of defense, or in many respects as the first line of inquiry from an individual who's interacting with the court system, this role is the most important in our legal system, right? The hallmark of a civilized society is the extent to which we provide zealous advocacy to our most disadvantaged and potentially most reviled members. So if you're a citizen in the state of Maine or any state who can't afford to pay for your attorney, the first thing that you're going to feel, of course, is a sense of being dispossessed, a sense of not being heard, a sense of being even more vulnerable and marginalized than you might already be. And then if you compound that by having a lawyer who isn't accessible on day one, who isn't there during arraignment, who isn't necessarily providing you with information about the path ahead, that will just feed into your sense that you are not a part of the system that is going to be respected and heard. So for non-lawyers in the room, it is hard to overstate the importance of a zealous and robust public defender system on the rule of law and enhancing trust in the system for people. You mentioned or you asked what it might feel like. Fortunately, I haven't felt that as a criminal defendant, but from talking to many, many clients, I do a lot of post-conviction work, the anger and the disdain that so many clients have for their former lawyers has tremendous ripple effects on how they proceed throughout their lives.
Thank you. So now let's, get into how each of these different systems operate and how they differ from Maine. And we'll do New Hampshire first. So Kyle, can you tell us how it works there?
So the New Hampshire Public Defender is a nonprofit law firm. So we are technically the largest law firm in the state of New Hampshire. We have about 280 employees and about 139 right now staff attorneys. And so we are a large private firm. We're not a state agency. That said, to your point earlier, our staff attorneys are unionized, and one of the benefits of that has been that legislation has been passed to allow us to join the state health insurance plan and to get access to some of those state benefits, despite the fact that we're not state employees, which has been great for us. So New Hampshire kind of has like that tier system. The first tier is us. The Public Defender's Office handles about 85% of the criminal cases in the state of New Hampshire. In calendar year 2023, that meant that we handled about 21,000 cases. When a case cannot go to us because of a conflict, then the next tier down is the contract system. The contract system is largely dying in the state of New Hampshire. The rate is not high enough. It's much lower than you have here in Maine. That contract system gives attorneys a consistent paycheck, but it's not an hourly rate. When I first started, there was probably over 40 contract attorneys that covered the state of New Hampshire. Now there are, I'd say, less than a dozen. And so that contract system is dying, which means that more people are going to the third level, which the third level is assigned counsel where you get paid at an hourly rate. We're talking about just cases that we are a conflict on go to those other two tiers. Everything else goes through the Public Defender's Office. And as I was sitting here listening to the panel before me, it really struck me that, New Hampshire, when we're lobbying for our budget, which we're currently doing right now because our position is we're very underfunded, we're talking about the fact that having a public defender's office saves the state of New Hampshire upwards of $20 million a year. Because we have in-house investigators, legal assistants, social service advocates, paralegals, all services that the state of New Hampshire would have to pay otherwise. And if you had to pay our caseload at an hourly rate, it would be substantially higher. And so there's a lot of benefits to us having our public defender's office handling the bulk of those cases. In addition to the benefits of the training and the mentoring and the community that exists in our offices, all of our attorneys start as a new lawyer class where they go through 5 weeks of training. Within an hour of the first day, they're going to be on their feet doing things. We have between 80 and 100 different attorneys that come in and do different portions of that training. And they start together as a class, and then they spread out throughout the 10 different trial offices that we have. So they have a sense of community, they have friends, they know people in every office throughout the state. And we bring them back together for follow-up trainings and other statewide trainings. And so that community and that training gives them that foundation that they start with. And then when they get to their home office, they have a mentoring attorney that shadows them and is there to answer their questions and be with them for their first experiences for their entire first year. We co-counsel about 8% of our cases. And so we co-counsel very serious cases, obviously, but then we also co-counsel very simple cases with our new lawyers. So that mentoring, that culture, that aspect that of our 10 trial offices, I think only one of them doesn't eat lunch together every day. Even our biggest office that has 30 attorneys, they all eat lunch together in the Manchester office every day. And so that sense of community and having case conference where we brainstorm and talk about cases, it really strengthens the system. And when we're looking at our offices, our smallest office, Littleton, has 4 attorneys in it. And those are all attorneys that have been practicing for close to 20 years. The amount of cases that those lawyers can process efficiently and very well is much higher than a second or third year lawyer. And so the state of New Hampshire gets a lot more bang for their buck with the more experience we have. And so we really try to retain our lawyers, and about a third of our lawyers have been practicing for 10 plus years. And it's because of that community and that culture. That said, not directly related to your question, but when I'm in New Hampshire talking to people, I tell everyone we are in crisis. We are in crisis because we lost 29 lawyers last year, which was a record high for us. Prior to that, we lost 22 lawyers. A few years back from that, we used to lose between 5 and 10 a year. 29 is definitely a high mark. Since July 1st, this fiscal year, we've already lost 14 lawyers. And why is that? I think that there's a few different things. One is that since 2010, there's over 20% less enrollment in law schools. Also, there are a lot less attorneys going into public interest. So we recruit nationally. So last year we hired 28 new lawyers. This year we're trying to target hiring 30 new lawyers. We also brought in 7 experienced lateral attorneys last year for our program. And our training and our mentoring really draws people in, but there's also this shift of there's less of a pool. And even though we reach out to all 199 accredited law schools in the country, if there's less of a pool and every public defender agency in the country is trying to pull from that pool and trying to expand, that's why we're in crisis. We cannot continue to lose lawyers at this rate, but we have to continue to expand. We have to get caseloads down. There is more of a emphasis from law schools about work-life balance, which also pushes people away from public defense. But I do believe that you can have work-life balance in a good public defender office, which is what we offer to staff attorneys coming in. But we're also, I think, one of the worst starting pays in the country. And we've taken the efforts of reaching out to public defender agencies in every single state in the country, including working with Jim and communicating with Jim and sharing information back with Jim and Chris to try to collaborate on funding resources because the system just does not put enough funding in the public defender agencies.
Yeah, well, it sounds like funding is sort of at the heart of all of this. And I definitely want to get at that and get at the recruitment and retention questions. Before we dive into that, let's look at Massachusetts. Dave, can you talk us through how it works there and sort of what's working and what isn't?
Sure. Excuse me. Certainly. In Massachusetts, the Indigent Defense System is the Committee for Public Counsel Services, CPCS. It's a 100% state-funded system that the CPCS oversees 2 components, a public defender component and a private counsel system. Unlike a lot of places in Massachusetts, the public defender offices are really focused on serious felonies and juvenile cases. And the lower level felonies, misdemeanors, and appeals are generally handled by the private bar. One thing about Massachusetts systems that's unique in most private bar systems is that they really do try to enforce standards and supervision over the private bar. So you can be what they call a bar advocate, in which you are paid to basically be a supervisor of a certain percentage of private attorneys that are around. You can sit in court, you can do mentorship, you can go through cases with them as well. And so it's a very robust system. Now, I should say one of the reasons is that Massachusetts is one of the highest indigent defense costs per capita in the country. And they are not paying attorneys at an exorbitant price, either the hourly rate or the public defender offices. There's a little bit of a unique aspect of Massachusetts, which is because there's so many law schools, especially in the Boston area, there tends to be more of a replenishing, and so it sort of has suppressed the salaries and hourly rate more than you would think in a system that spends so much money. But there is an emphasis on all the things we talked about: mentorship, social service advocates, and other things like that, investigators and others, to really bring a lot to bear on that system.
Great, thank you. So I'd love to think now about, what Maine can take from these 2 systems. And so if it were up to you and you were part of starting, Maine's new public defender network, what would you encourage and what would you advise against? And Daniel, you made the comment about, taking lemons and turning them into lemonade. So I'd love to hear from everyone on this, but we'll start with you.
Thank you, Stephanie. So with that in mind, maybe a love child between New Hampshire, Vermont, and Massachusetts would really work well for Maine. So let's take sort of the best features of what we've heard and blend them together. Huge benefit, of course, in New Hampshire. I think Kyle mentioned that 85% of indigent clients are represented by the New Hampshire Public Defender's Office. That is great because that ensures a uniformity of zealous advocacy, supervision, training. You can make sure that caseloads are managed properly. That's a really fantastic balance. The balance in Massachusetts is different. Dave, correct me if I'm wrong. I think here in Massachusetts, about 80% of indigent clients are represented by a bar advocates assigned counsel and 20% by CPCS, even though CPCS really supervises and oversees the assigned counsel bar. Many of us here in Massachusetts would like, a greater number of public defenders in CPCS, a more robust sort of office, okay? So maybe a blending of the two where Maine could have a large public defender office in a hybrid model, a little closer to New Hampshire, but to follow the Massachusetts image of having a public agency that oversees it. Kyle mentioned that, of course, the New Hampshire Public Defender's Office is a private nonprofit. And it's worked out relatively well in New Hampshire because you have a very good bar and you've negotiated very well with the state. But in a lot of other places, the private nonprofit can be undercut through RFPs, where other private nonprofits will compete for the bid from the state. So for instance, when I was in New York City, I was at a private nonprofit, the Legal Aid Society, and we would bid for the Indigent Defense contract in New York City. But we were competing against all of these other organizations. And the city, of course, trying to be fiscally responsible, would often go for the low bidder. And low bidders are not necessarily consistent with zealous and effective advocacy. So Stephanie, to answer your question briefly, sort of a blending of the New Hampshire emphasis in terms of the balance, most indigent clients being represented by institutional public defenders, but with the Massachusetts model of having a state governmental public defense organization.
Great. Dave or Kyle, do you want to take a stab at that?
I think for me, the three big things I think is one, being a statewide agency or being a statewide entity. I think that when you're looking at what law students are looking for, a lot of what I hear for is they're looking for a state facility, something that runs the whole state, which can have a lot more resources. I think not undercutting legal assistants, paralegals, social service advocates, investigators. I think that is a huge aspect. We've existed since 1972, and we've had legal assistants and investigators since pretty much the beginning. Social service advocates and paralegals are newer to us in the last few years, but they save us a ton of resources. And I think really investing in mentoring and training in that community is huge because we are recruiting with much more populated areas. And I don't know if Maine is this way, but in New Hampshire, the bar is shrinking. We have less lawyers in the state of New Hampshire. We have less lawyers coming to live in New Hampshire. And the Public Defender Agency historically is an entity that has brought lawyers to New Hampshire, and then they've stayed and created families in New Hampshire. But the bar is shrinking, and it is about to shrink a lot more in the coming years as a lot of folks that are attorneys are hitting the retirement age. So I don't know if that's on the horizon for Maine, but that's something we're definitely looking at in New Hampshire. And I guess the last thing I'll say is that vertical representation is huge. There are a lot of state agencies that you can do arraignments as a brand new lawyer for 3 years before you ever do anything other than an arraignment. You are in the same courtroom with the same judge and the same prosecutor every day, and you don't have that variety. All of our attorneys handle a mixed caseload. They handle misdemeanors, felonies, and some attorneys handle youth cases as well in that mix. And that variety makes the practice much more sustainable from our perspective and more of a rural community. And so I think that mixed caseload and that variety is important.
And just to clarify for the non-lawyers out there, vertical representation is following a case from beginning to end. Is that right?
Yes, that's correct.
Okay.
Horizontal being you have lawyers that just do arraignments, you have lawyers that just do probable cause hearings, just do misdemeanor trials, and just do felony trials. That model is not as attractive when you're recruiting, in my opinion.
So just as we heard in New Hampshire, that second tier is going away, that contract model. That's true nationally. We are seeing state after state ban contracts, especially flat fee contracts, because they naturally have either incentives or disincentives for attorneys to do the full work. If you're being paid the same amount, no matter what work you do, not all attorneys, but a certain percentage of attorneys will try to do as little as possible to focus their time on others. So states like Michigan, Nevada, and others have banned the use of contracts in indigent defense. I believe in that. I think all systems should be a combination of state government employed public defenders and private attorneys paid a reasonable fee. Right now, most states are in the 100 to 150 range. It's still not enough to be able to cover what's needed to handle those cases. But I think if we have those two as the principal systems, that will be great. I do want to add one more thing to the Maine conversation, is in many ways, the Sixth Amendment Center filled a void that was in Maine at the time that we were studying. And that was, there was no institutional voice to the policymakers about what was going on. In my time, I was quite impressed with the Judiciary Committee in Maine that we worked with. I've worked with legislatures all over the country. I thought the combined the combined Senate and House, having both sides of the aisle, Republican and progressives together, I was quite impressed. My friend Tom Harnett's here. People like your Secretary of State, Bellows, Senator Lisa Keim. These people were people that were very invested in doing it. We felt like the gap was the judiciary branch and the executive branch in this state, that there wasn't constant outreach in doing that. When you have well-developed state systems, you also get, besides just the oversight, management, and mentorship, but you get that external communication where you're constantly educating the policymakers. So some of the great ideas we heard on the first panel that could be advocated, why isn't there sort of an institutional presence? I know and the commission has changed a little bit on that front from where we were back in 2018, 2019. But that's what needed, advocating for decriminalization of things, reclassification of crimes, those type of things that Tina, Ron, and Rob talked about in the first panel. That is missing in Maine because there is no institutional provider that's constantly on the three branches of government forcing those types of change.
Yeah, that's a good point. So one of the challenges in Maine, and I think probably most places that's come up today, is recruitment. And that's, a particular challenge in the most rural parts of the state, like Augusta County, which Rob was mentioning earlier. Kyle, you mentioned this new class of attorneys that happens every year in New Hampshire. Can you tell us a bit more about how that works and how that sort of addresses this recruitment issue?
Yes, so we recruit nationally. So we reach out to all 199 accredited law schools in the country. We send flyers. We sign up for on-campus interviews. We do on-campus interviews, which are largely remote all over the country. Any school that reaches back out to us and invites us to an on-campus interview, we try to do them. We also get involved with Equal Justice Works recruitment. We recruit hundreds of people there. In total, we get hundreds of applicants between interns and staff attorneys. We process through, I'd say, over 1,000 applicants a year. And so we cast as wide a net as possible and do as much as we can to get the word out there as to what we have going on, creating relationships with different law schools. We offer for people to come and shadow in New Hampshire, to shadow an office, to see what it's like, to have lunch with one of our offices. We do everything we can to try to recruit as big of a group as possible. And then we kind of narrow that down and getting into 28 new lawyers. And the 28 new lawyers that we hire, One of them in this room right now are very impressive. They're people that we have a lot of confidence in, and they're individuals that we know when they show up on day one, that they're going to be able to handle a large volume of pressure. But we're going to build their caseload very gradually and have a mentor with them each step of the way. And getting the word out there is important for us.
Yeah. Are there, Dave or Daniel, are there other recruitment efforts that you've seen work well elsewhere, or things you would like to see to get lawyers into this work? Dave, I'll let you. Oh, either way.
Oh, great. Thanks, Dave. Yes. So as a law professor for many years, I think I do have a couple thoughts of things that could work. The first is if you can establish a pipeline through a state law school's clinical program, that can be very effective. Kyle, I imagine, I'm not sure, that a number of your hires come out of the UNH Criminal Defense Clinic, or at least are interviewing with you. So one suggestion maybe is if and I know Marcia Levy is there in the audience, and maybe Marcia will enlighten us during the break. But if the University of Maine had a funded criminal defense clinic, I think that could be really helpful to establish a pipeline. The second thing I'd like to mention is, as Kyle pointed out, students do actually want to move to Maine. I have a number of students in Boston who would love to come to Maine, but they don't even know how to access the bar and find a job outside of the larger law firms in Portland. And having the simple existence of a Maine public defender's office and having a repository for applications to be received and vetted by itself could be a major, major lure. What I'm seeing more and more from students is not just the work-life balance, but it's also an escape from the high cost of urban living. And so a lot of students would be, I think, open to living in Maine, a beautiful state, in part because of the lower cost of living too. So I think recruitment, both in terms of establishing a clinic and then actually marketing the existence of an institutional public defender, could go very far. I often say that the two keys of establishing a public defender agency are the two F's: to fund and find. So if you can figure out the funding, I think the finding might not be so difficult.
One other thing to add is addressing student loan debt. If there can be student loan forgiveness to go into indigent defense systems, sometimes this is done through state systems, through their state law schools, to have a partnership to do that. But then there's also programs that are just simply, if you're in for 5 years, we'll relieve a certain portion of your debt. That's another giant concern that we're hearing from the next generations coming out.
So, we've heard a lot about work-life balance. And of course, the next question after recruitment is, once we've solved that, is retention. How do you retain lawyers? How do you create this work-life balance? In New Hampshire, in Maine, people are leaving the profession, and we saw a lot of that after COVID, like they said in the first panel. What are some things that are working elsewhere? Is it caseload caps? What are some strategies that you've seen that are helping make this a viable profession for folks? Kyle, do you want to start?
I think that's the $1 million question, is, how do we approach that? I think that caseloads, from my perspective in New Hampshire, are higher than we'd like. Our target is to have lawyers under 70. I think statewide right now, our average is in the 80s. But we're looking at caseloads and we're saying, okay, this is what caseloads are. 70 has been our target for years. But what goes into a case is substantially different today than it was or even just 10 years ago. Our technology, our data has increased since 2018, 869%. That's a huge number. We have a lot more body camera. We have a lot more videos to process through. A case that used to have just, a 2-page police report now may have 20 hours of video. Which can be us trying to find a needle in a haystack, which is why we have to look at other resources to try to like paralegals and technology to try to reduce that time and not just look at the caseloads in the same way that we always have. We need to adjust and say, okay, actually maybe 70 is too high. And we need to actually be even lower than that. How long is a case open? I found it interesting earlier when we were talking about dispositional hearings. New Hampshire, we've tried to move away from dispositional hearings and just have trials so that we can move cases faster. Cases that used to be open only for 3 months, now in New Hampshire sometimes are being open for 9 months. So that's 9 months of working with that client, processing that discovery, getting experts. And if it's just going to resolve as a no-time misdemeanor, we put a substantial amount of time into a case that can be much shorter. And so we're looking at different ways to try to reduce caseload, both in how we process information, but also in how the court processes that information, and trying to advocate with the court as a state agency, like, look, court, this will actually save you time. This will be more time for the judges on the bench because we will be able to close more cases quicker and more efficiently versus taking 9 months with 5 hours of court time to get to the same result. And so we're trying to do those sort of things to reduce caseload, but also to expand, to have more lawyers. I think just a few years ago, we were around 120 lawyers, and now we're at 139. And having those more experienced lawyers will help us to process cases more efficiently, and having the mentoring and training again to really be able to work a caseload properly.
Certainly lower caseloads and greater support staff so that lawyers are doing what lawyers are skilled to do and not doing a lot of the extra stuff. And having the ability to learn from particularly social workers about how to identify certain things and things like that. I do want to add, just going back to the last question, but it ties in with retention too, is the other thing of an organized system is that you can attack the system's injustices that your attorneys are seeing. Many state public defenders have special lit departments that are taking up some of these things that we're talking about, some of the injustices that you see. If you can have those type of units, both because it empowers the line attorneys to feel like the system is changing, but also it can be a rotation in to give you a break out from being trial day in, day out type stuff, to be able to do that.
Just if I can piggyback off of that, we have attorneys that do specialized treatment courts. Treatment courts, being a team member on those treatment courts reduces recidivism. So you're talking about having less cases moving forward, safer communities, and our attorneys get a lot of satisfaction by being a part of that treatment court team. We have mental health court, veterans court, drug court. We even have a young adult court. And we also have opportunities where we have an appellate office where attorneys can rotate into the appellate office and do 2 years in the appellate office and then transition back to the trial office. So they have that appellate experience and that different perspective, and those different opportunities that really kind of give lawyers the opportunity to develop and grow in different ways than just having a traditional caseload.
If I could just jump in, Stephanie, on this briefly. Studies about career fulfillment often mention 3 things, right? The first relates to the intrinsic value of the work, how meaningful it is, how intellectually rigorous, and being a public defender has that, right? If you go into this work, you often have a sense that you're doing something meaningful and it's going to be intellectually challenging. The second factor, of course, is work-life balance, which Kyle and Dave have identified as perhaps the most important variable here. What is the quality of your life? And case caps, the availability of things like job share arrangements, parental leave, all of those things are really, really important. But the third thing that is actually low-hanging fruit that perhaps Maine could do relates to another aspect. It's not about the intrinsic value of the job. What is it like for you day to day? But it's about how you're perceived externally and your sense of self and whether you feel valued. And what some of these studies suggest is that very simple things like giving people nice titles or plaques or awards or even a shout out on email can be instrumental to retention. It sounds silly, right? But I've known a number of colleagues in my jobs who have been fueled for months through a simple shout out on email from their supervisor that goes across the organization. And little things like that are created culturally can go a long way toward keeping people in an office.
Yeah, I think that's a great point. Everyone needs a plaque, you know? It's always good. So Kyle and Dave were just touching on this a little bit, but you know, obviously a lot of the changes we're talking about are focused on the criminal defense bar, but this, you know, the change that we're talking about involves the whole system, and we're changing processes for judges, for clerks, for prosecutors, and everyone else in the system. What are things you've seen work elsewhere, or you think Maine policymakers and officials should keep in mind when working to implement this system-wide change?
I think the thing that comes to mind, and I thought of this after your question earlier, is that when somebody doesn't have an attorney, what does that actually look like? And so in New Hampshire right now, I checked this morning, for cases that we're a conflict on, we have 85 not have an attorney. And if the conflict clears, we may get that case back. We'll take it back and we'll do it. And I may get that client who's now been sitting in jail without an attorney, and within 24 hours, I'm going to get them out of jail because their case was stupid or their case didn't warrant jail. They just needed somebody to actually speak for them in a hearing. But now they're going to get out of jail, and they've been in jail long enough where they've lost their job, they've lost their housing, all of their personal belongings that were in their apartment just got thrown in a dumpster. So they have nothing. They may not have family support. They may be struggling with mental health. They maybe have taken off their medications. If they're struggling with substance use, they've now been sober in the jail, or maybe not, for an extended period of time. They're going to get released. They're going to use at a higher dose. It's going to have a more significant impact on them. And it's just going to cause more problems for society. If there's a victim involved, the victim is more at risk than ever before, because you've now taken away this person's livelihood, this person's home, this person's belongings, and they have nothing. You may have even taken away their medications. And so it completely counters everything that the system is trying to do. And so that's what it looks like when you don't have an attorney from somebody on day one. Never mind the fact that, like, if I meet with a client right away, I might be able to get them in treatment, get them the help they need, get them signed up for medications, get them in a much better position to negotiate their case. Or I might be able to investigate and find out that they're truly innocent because I got the video that's going to erase in 7 days. Or I got the witnesses tracked down that maybe we're going to leave the country. And those sort of like results, you can't say enough about. So when I heard the number that existed in Maine, it blew my mind, because that's just hurting society in every way possible, including the victim, which by the time you end up getting to a result in the case, a lot of times the victims have just given up all hope in the system, and they don't even want to be involved. And so then the prosecution sometimes can't even get a conviction if they wanted one. So that would be my message to legislators in Maine.
Just to piggyback on to some things we said earlier, that idea of when we were studying the system in 2008, MCILS at that time, besides the people that were just doing some of the case processing type stuff, they basically had two and a half people to do all the supervision of all the cases throughout the state. They couldn't possibly do that job, let alone all the other things that come with a good public defender system. So I was saying, in many ways, I felt like the Sixth Amendment Center was filling one void. But there's other aspects, right? The ACLU was filling sort of the special lit void. And I don't want to let this opportunity pass without publicly thanking the Maine Monitor for the amount of quality spotlight pieces on these problems. It's something that the system should be doing, telling the client stories instead of having it come from the press to be able to do that. That's how you get the systemic reform beyond just indigent defense, but to the judiciary, to the prosecutors. One thing I'll say is we've been sort of promoting reclassification or decriminalization. One thing to be cautious about is that if it's done within a void, because we've seen this done in several states, right? If there's not sort of prosecution reform or restructuring, then you take a certain number of cases off the table. They still have attorneys that have to do something. And so they bring the other cases that they hadn't brought before. So it really is a complex jigsaw puzzle that has to go through. But when policymakers are not getting the client stories that the Maine Monitor did, the systemic sort of challenges that the ACLU did, or some of the advising that we've done, you're really at a disadvantage to try to get those broader criminal justice reforms.
So I like what Kyle was saying about, what this painting this picture for us of what it really means. And, we're focused a lot on the right to counsel, but I think maybe this is a good time to think about ideally what would, how can public defense systems help people in other ways, providing social services, this idea of holistic defense. Are there particular models that you would point to that are working well? What are some of those, thinking more broadly outside of just providing people with lawyers? What are some systems that we can look to?
One of the things you've raised is this idea of holistic community-based defense, which is something I'm a very big promoter of. Everyone that calls themselves community or holistic base has a somewhat different approach and opinion of what they're talking about, but just a couple of models. In Knoxville, Tennessee, you wouldn't think of Tennessee as being one of these epitomes of indigent defense, but they have a holistic approach where they really just think outside of the box. And so what I'm talking about here is the public defender office hosts an after-school program. They identified one of the problems was kids having too much time and too much unsupervised time. So this public defender office has basketball courts, soccer fields. They have dramatic arts centers. They have all sorts of things to try to inspire children of what they need to do. They have a cafeteria that serves hot meals under the recognition that a lot of kids have food insufficiency. And what they need is to make sure they have a safe place to have a meal after school's let out because maybe they missed lunch or something like that. And they really tried to get at what is the reason this child or this adult has come in contact with the criminal justice system. Something really must have gone wrong in that person's life. And so it's not just what is the case, let's process the case. It's really trying to get at what went wrong in this person's life to do it. In Massachusetts and CPCS, they have the youth advocacy program or division now. And they do a full 360 screening of that child. Does he have dental? When was the last time he went to the dentist? Maybe he's embarrassed by his teeth and he doesn't speak up in class because he doesn't want people to see his teeth. And that sent him on a path. Maybe they need education lawyers. They have staff psychiatrists. It's really broadening this idea of, no, our job is just to do the casework on this, and it stops once we're done with the sentencing. It's a much broader approach to what it takes to do it. And all that is possible when you have systems and the ability to do beyond what Maine has done.
So I agree with all that, but the one caution that I always give, because I was on a drug court team for 6 years, I've been on a veterans court team for 8 years. I think that there is a lot of benefit to providing those services for clients. But I think some agencies can fall down the slippery slope of not meeting clients where they're at and not being a stated interest public defender. Immediately meeting with a client and saying, I'm here to fix you versus I'm here to be your voice. I'm here to advocate for you. My job is not to convince a client that they need to be fixed. My job is to meet them where they are and hopefully leave an impression on them. So when they are ready to get services or they are ready for a change, that they feel comfortable to reach out to me at that point. So that's, I think, the one caution that I give for more holistic representations is you really can't go down that rabbit hole.
Daniel, did you want to speak to that at all?
Sure, just briefly. I see three major benefits to holistic representation. As Dave mentioned, there are different types of models out there. The first, obviously, and the most important one is you can help the individual client on such a fundamental level. The second really relates to the optics, which is quite important when you're thinking about convincing legislators to fund the office, because in many ways, public defenders are viewed as oppositional, right? Oppositional to law enforcement, as oppositional to convictions. But if the role of holistic representation is also crime prevention and to prevent recidivism, then that is more aligned with a lot of more conservative, for lack of a better term, views of the system, and might actually help your funding and your intra-state reputation. The third, of course, which is really, really important, is that for fiscal reasons, one of the biggest selling points of an institutional public defender is cost savings. And it's very hard to quantify the cost savings of actually having a good institutional public defender. But Kyle's story about what someone experiences when they don't have a lawyer, the converse of that is if you do have a lawyer and you get bail, you are saving the county X days of funding for someone's time in jail. And that's a huge cost savings to the government. So by having holistic representation, by having a vigorous defense and a holistic defense, I think part of the sales pitch that's really important is this is fiscally responsible. You are going to save the state money through crime prevention and decarceration.
Thanks, Daniel. So I want to make sure there's time for audience questions. So we'll move to that in a minute. But first, I wanted to get at one kind of specific question, which is, we talked about the COVID backlog of cases earlier. And, during the pandemic, we saw some courts embrace video hearings. And I think, that, like Rob was saying, that led to, more lawyers in some of these further harder to get places like the county. Is, this idea of video hearings, is that a good thing? Are there places that are considering moving to that more permanently? What are the sort of pros and cons we should be thinking about and thinking about video hearings?
When I first moved into administration, I had strong opinions about this. But since I've evolved and changed and realized that it's really not a one size fits all. We have parts of the state of New Hampshire where video hearings are impractical and they're inefficient, and the jail is just 2 miles down the road, and transporting clients can be much more effective. But then we also have more rural locations throughout the state where we're asking defendants to drive 2 hours to get to court when they don't have any money, they don't have a license, they don't have a car. It's not realistic. And then I'm also asking that attorney to be in 2 different courthouses that are about 2.5 hours apart from each other at the same exact time. It's not going to work. It's not practical. Videos can be used efficiently in those environments, but in some of our other environments, they're an obstacle to actually resolving the case because you don't have meaningful access to your client. You don't have that same confidentiality access. You can't have the back and forth with the state. Maybe it takes you 30 minutes to get through to the jail to talk to the client. It's just not practical. And so I really caution against a one size fits all approach in what actually works for you.
I think it's safe to say the Sixth Amendment Center's view on remote courts and video is evolving. We certainly know, and he's pointed out many of the problems that are built into those systems, especially if the prosecutor's in court with the judge and and you're remote or your client's remote, there's all sorts of problems that come. What I do want to underscore, though, not that there was any silver linings in COVID, but one of the things we learned during that process was no-show rates plummeted. And it turns out that when people don't show up for court, it tends to be a whole host of reasons other than they just don't want to be there. It's coverage for kids. It's not having transportation. It's all that. And so I think what that taught us was there really is issues with getting people to court to their hearings, especially in rural America. I've been in counties that, could have two courthouses 3 hours away from one another. It's really difficult to do it. But what I think changed people's minds were the no-show rates were almost disappeared because of that.
That's really interesting. Daniel, do you have thoughts on remote court you want to share?
Nothing much to add except for the idea that obviously the preference should be for an in-court appearance, but it could be a rebuttable presumption if there are problems with inefficiencies. I think the only other thing I'd add is I think it's important, of course, to make sure that the client understands the potential consequences of each route, right? Because I think there are potentially deleterious effects of remote hearings in terms of the judge getting a sense of the person and the human and the face-to-face. But as long as the client has informed consent, I think could be useful, obviously.
All right, well, we're going to turn to audience questions now, and we have a mic. Emily has the mic in the back, so if you have a question, you can raise your hand. Looks like we have one here. Thanks, Peter.
Thanks. One issue that comes up in talking about any one of these systems very early is the money. And turning to our friend from the Sixth Amendment, do you have comparative studies of the cost of these various systems, say on a per inhabitant of the state or per case handled, that could be used, and also in the Maine system, that it can be used in going to legislatures and saying, this is what we need in Maine?
The short answer is yes. The long answer is more complicated. It's very difficult to compare systems to systems because there are, states define cases differently. Their systems handle different cases. Is the whole family court system rolled into the indigent defense system? Is it in an entirely different system like in New York? There's all sorts of factors you wouldn't think about. The highest cost per capita in our country is Alaska, but it's because public defenders need to fly to all the courts. And so there's just, it's a nuanced approach that we like to think that's the role we can play to explain to legislators all those nuances to do that. Right now, roughly the average cost per capita for indigent defense is about $20 per person, and that's in a country where indigent defense is undervalued. I don't know where Maine falls at this moment. We can figure that out on that scale. But when we did our study, Maine was well under the national average. There was an immediate influx of money, mostly due to raising the private counsel rates. And so there was a response to that, but that's a role that we can continue to play, and will always support Maine to get to where it needs to be.
How about New Hampshire?
So as I was thinking of your question, just a few weeks ago, we presented our budget to the governor's office, and we did a side-by-side comparison of here's what NHPD costs. And if you didn't have NHPD and you were just doing assigned counsel, here's what it would cost. And here's what it would cost if you had to get court funds for investigators. And it is a significant savings. And that's even including our request for more money, since we are one of the lowest starting pays in the country. And so I do think you could look at our requests and see that side by side and say, it's got to be same in Maine. And our assigned counsel rate is not as nearly as good as Maine. And so I think the comparison for you guys would be even more significant than it is for us.
At the time of our study in New Hampshire, it too was right at the national average, if not a little bit below, if I'm remembering correctly. So in the New England area, Massachusetts, Connecticut, Vermont are all significantly above the national average. Rhode Island, New Hampshire, and Maine are at or below the national average.
I think we're at 90 right now an hour. We're trying to do rulemaking right now to raise it to 125.
Hi, Rob Ruffner. Throughout the panel's discussion, there were an institutional presence or an institutional voice was mentioned. Vermont has a Defender General. Are there equivalents in New Hampshire and Massachusetts systems, or if not in position, in effect?
Yes, so Vermont is unique. It's the only state in the country that has a Defender General seen on par as with the Attorney General. But in effect, the other New England states do have that. Massachusetts, it's the executive director of the CPCS. Connecticut and Rhode Island have chief public defenders. We've heard from New Hampshire. So that is a position which really is missing in Maine, and one that's unique to the New England states for not having it.
Another question in the center.
Also, I think there might have been a question in the chat, but it came up before. I wanted to ask about, you've been talking about getting young people into criminal defense and whether you've looked at some of the fellowship programs that exist in other parts of the country, things like Gideon's Promise or Equal Justice Works has a fellowship program. You know, on the immigration side, New York has the Immigration Justice Corps that gets people trained, gives them places to, you know, practice, but does training. And so after, you know, a year or two, they can go out, you know, into practice. And I wonder if any of that is being looked at as a way to get people in, or, you know, what you think about that.
But you go first.
I'm certainly familiar with Justice Works. I don't know enough to sort of speak publicly on that. I'll speak about Gideon's Promise though, because I do think it's a phenomenal training system for young attorneys that inspires them to do it. What we've seen is that Gideon's Promise is most effective when it attaches to a well-structured indigent defense system. Even in the movie about Gideon's Promise, many of those attorneys are no longer in indigent defense because of burnout, because of, you know, I can tell you, you know, you train up an attorney and you put them into Mississippi. Well, if they start challenging the system, they're never going to get appointed to another case. And so it really is another side benefit to having a well-structured indigent defense system, is that's where a system like Gideon's Promise can really come into effect. I've talked with RAP many a times where, you know, one of my goals would be to institutionalize Gideon's Promise in every state so that it becomes the standard for training of new attorneys and ongoing training for existing attorneys.
We have one question from the chat, which is why not always ask for an ankle monitor in lieu of jail in non-felony cases? And why not have a system which is set up for that?
Why not always ask for an ankle monitor?
Yeah, instead of jail in non-felony cases.
So that may be a question that's better for a Maine practitioner, but in New Hampshire, we have, in some counties, we have pretrial service programs. In other counties, we don't. Ankle monitors are not always accessible. Ankle monitors also sometimes in New Hampshire come with a cost that our clients can't afford. And so if it's a choice between being in the community on a bracelet or jail, I agree with you. Let's go with the bracelet. But that's not always an option in New Hampshire, at least.
Any other questions? If not, I have one last question for the panel. Can you just wait for the mic so they can hear on Zoom? Thank you.
This one probably should have been asked by the prior panel, but it's prompted by our friend from New Hampshire's response. That we were sitting here and saying that seems like an awful lot of people in jail waiting trial here in Maine, and aren't they getting bailed, or can't they get bail or personal recognizance? Why do we have so many people in jail, and wouldn't be part of our problem be somewhat ameliorated if at least they weren't sitting in jail, but could get out and get around in the community and mobilize resources?
I agree. I agree with that. And, you know, New Hampshire has seen a bit of a roller coaster. We did bail reform. Our jail population, Manchester, for example, went from 500 to like 250. And actually, the thing that we don't talk enough about is that crime rates then went down. Because you didn't have that example that I gave earlier with the housing and the jobs. And I didn't even add the layer of children and having to pull children out of the home and what that does. So crime rates went down, but then, you know, you've got a couple of banner cases and people advocate for bail reform to be undone, and it's been undone a little bit. And then in January in New Hampshire, we're undoing it a little bit more. And so our jail population is going to rise. We'll see what happens with that, but it just adds a lot more difficulty to everything that we do. And I'm not sure that it actually makes the community safer by incarcerating more people pre-trial.
All right, I'd like to end on sort of a hopeful, optimistic note and ask for solutions. So I'd like everyone to take this. If you had a pot of money and you could sort of just go fix one thing in indigent defense, be it in Maine or elsewhere, what would you pick and how would you fix it? Easy question, I know. Daniel, you want to start us off?
Sure. So going with the lemonade theme, Stephanie, let's make it blueberry lemonade, right? Because we're in Maine. We want to make sure that it has some Maine characteristics to it. So the first thing I do is I want to hear from the Maine bar about what, it's very easy for someone from the outside from another state to come in and say, hey, this is what I think should happen. So that's the first thing I'd want to hear from the Maine bar about what they think. But if I had that pot of gold, I would set up a statewide institutional public agency, public defender system similar to Massachusetts that would provide the requisite oversight and caseload management and training that would really provide effective both substantively and cost-effective representation.
I don't know if I can say it any better than what Daniel said, so I'm going to say ditto.
Great. Kyle?
I agree. I'd set up a state entity that can handle public defense that would put a real emphasis on community mentoring and training to make it a sustainable practice that you can have for a career, not just a stopping point on your resume.
Great. Well, it sounds like we have a clear vision here. Thank you all. Let's give a big round of applause to the panelists. And I think next up is lunch. So we're going to learn where we're going to go for that soon. But thank you all.
Our third panel here. As we've heard a bunch of times here, Maine was the last state to launch a public defender system. The state's first public defender's office, the Capital Region Public Defender, opened last year, led by the state's first district defender, Frela Tarpinian. Other district defenders have been hired to run offices across the state. Attorney Molly Owens has been hired to build a team of attorneys to represent indigent parents of children in child protection cases. But as the numbers I talked about this morning show, we still have a ways to go. And as other states and jurisdictions demonstrate, Public defender's officers are no guarantee of solving problems related to indigent defense, but of course it's a start. So I was hoping to talk about those efforts, where they stand, and what's ahead. With us, we have, starting over there, Professor Sarah Branch, Director of the Maine Law Youth Justice Clinic. Freyla, as I said, the District Defender for the Capital Region, which is Kennebec and Somerset, if I'm not mistaken. And Jim Billings, Executive Director of the Maine Commission for Public Defense Services, as it's now known. District Attorney Maloney was, I believe, originally scheduled to be here, but she has business at the State House, so she wasn't able to meet us today. So we did make an effort to bring in a prosecutor to defend themselves against all of you. We weren't able to do it. Anyway, so I guess first of all, there was some talk in the last panel about having sort of an institutional voice representing defense in Maine. I guess my question, Jim, is that you?
Well, for now it is me. I'm the best we have to offer. My apologies to others who aspire for more. Yeah, I think I heard a lot of good stuff today. A lot of the stuff that we heard, we are already working on in some capacity, at least the good ideas. I didn't really hear any bad ideas. So we do work with Shira Burns. We are in the middle of talking to her about a statutory package to try and decriminalize some offenses. She tried that before with near universal support from her constituency, the Maine Prosecutors Association, but a lot of those efforts stalled out in the Criminal Justice Committee because the legislators do not follow crime statistics, they follow polls. So that remains to be seen whether we'll have success in the upcoming session. Oh, I think we're trying to focus on a lot of the driving stuff. In particular OAS, which just to follow up on something I think Rob mentioned in the morning session, you talk about the Aroostook County being the size of Connecticut and Rhode Island. You should think of it another way, really. There's roughly 68,000 people that live in Portland, which is 2.5 square miles. There's the same amount of people that live in Aroostook County, which is 6,700 square miles. So those people are spread out. It's almost 2 hours to drive from one end of the county to the other, from Holton to Fort Kent. Our office is located in Caribou, which roughly splits the difference an hour, more or less, either way, north or south, to cover the county. So when you think of those spaces and the person who gets some form of civil judgment, or they didn't have their insurance card when they got pulled over, or their inspection sticker lapsed because Maine insists on vehicles being inspected. And, you know, for some reason, if you have a car garage, that works to your advantage to give someone a list of things they need to get fixed before they can get their magic sticker. You end up getting someone in the system who may already be living paycheck to paycheck, and then they can't pay their fine. They already couldn't pay their insurance. They couldn't pay their car repair. They keep driving because they've got dependents. They have to get to work or take people to doctor's appointments. They get repeat offenses. They then will get a violating conditions of release, Ellie's favorite statute. And so you get this sort of pile-on effect of this disastrous impact on this person who is most likely not a career criminal.
That's true.
So those are issues that are not unique to Maine, but they get, I think, aggravated and elevated in a lot of rural Maine where there's no public transportation, no meaningful public transportation. Maybe within a city, it could be a bus route, but it's not connecting you to services all over the county.
Yeah. Jim, before I move on, can you just give us a sort of snapshot of where the public defender system is right now in terms of the various rollouts across the state?
Yeah, so we had the RDU, which was a roving band of folks that would go from wherever they live, which was mostly southern Maine, and they were mostly focused in Aroostook County. those positions are being phased into a parents council unit as those people from the RDU move into brick and mortar public defender offices. And so of the original 6 positions, I think we have 2 currently right now still in the RDU as line attorneys. The district defender for the RDU became the district defender for the Caribou office. So the Caribou office and the Bangor office were created in the March emergency bill that went into effect immediately in this last short session, was taken out of the budget, and it was a standalone bill to create those 2 offices. And then the Lewiston and Ellsworth offices were created as part of the normal larger budget that passed and became effective August 9. And so after getting the Capital Region office up and running last fall and staffed with attorneys December, January last year, and not staffed with support staff until really the spring of this year, that unit is humming along, and it's basically kept an unrepresented list from accumulating in Kennebec and Somerset County. Now, there are periods of time on individual cases where there's going to be some scurrying around by the court to find a lawyer, but they do not have the 150 or 200 or 300 cases on a list that they have in other parts of the state. Aroostook is, Toby Gendreau is the old RDU district defender who took the Caribou public defender office position as a district defender for that office. He has 2 line attorneys that are AD1s. In our vernacular, an AD1 is someone with some considerable experience doing criminal work. Those 2 positions went to a couple from Louisiana that moved to Maine. And for those of you who don't know, if you're from out of state, and we have to recruit out of state, you heard Kyle from New Hampshire talk about their national recruiting efforts. We have to recruit out of state people and new graduating students. And we have to recruit people that aren't already doing this work in order to increase system capacity. Because if we just take someone who's already doing this job 100% in the private sector and move them into a PD office, it doesn't fix anything. So they came, and it's taken most of our people that have come from out of state 6-8 months to get admitted under the Bar Rule 11A, which is the reciprocal admission motion. We have a volunteer board of bar examiners. It's really through no fault of their own. They rely on national resources to do the checks they need to do to admit people. But one of our successes was getting the bar rules amended to include a Rule 11C, which allows anyone who's going to come to work for us in a supervised setting as a public defender to have sort of a provisional licensing so that they can begin practicing almost immediately upon coming to Maine and joining one of our offices. And so that rule amendment became effective September 23rd, and by I don't know, October 10th or something like that, they got their provisional licenses. And so they're taking Aroostook cases, and they had years of experience in public defender offices in Louisiana. And then Kenzie DeVoe, one of the last remaining RDU members, is in a position that was created for Aroostook County. She's doing work in Aroostook County. There's an AD2 position in Aroostook County that's vacant. We've had some trouble filling that position. That's an entry-level position. And then we have an office administrator, and we have an investigator. One of our first in-house investigators is hired in Aroostook and is now working, which allows our public defenders to work intimately with the same investigator over and over again on all their cases, which I think is a good advantage that law enforcement and the DAs have, and building relationships like that and familiarity with how you want things done. And it gives everybody a jump start on handling those cases. There's a couple other, I think there's a paralegal position that we're still trying to fill up there. Bangor was next. And so Logan Perkins is the district defender in Bangor. And she has 2 AD2s working with her, and she has Dagan Vandermark, the other RDU holdover, who's working in Bangor now to try to help out in Bangor. Bangor has sort of taken over, the Penobscot, Piscataquis region has kind of taken over from Aroostook as the sort of dubious distinction of having the most cases on the unrepresented list. And so we're trying to move as many resources there as we can. but we've had a real difficult time hiring in Bangor. We're not alone in that. We've heard from private firms that they have similar phenomenon. That it's very difficult to get, especially young students who are not, even if they're not from Maine, they want to stay in Portland. Once they've had 3 years in Portland, they don't want to go back to the farm. So we've got a gentleman starting this month, I think in a week, Monday, who's an 81 in the Bangor office. And we're in the hiring cycle for another 82. We have some candidates we've interviewed. We think we'll be making a decision on that soon. We do have some staff in Bangor. We have an office in Bangor. We have an office in Caribou. So Bangor's coming along, but it's been a challenge filling those positions. The Ellsworth office, Max Coolidge is here. He's the district defender for Ellsworth. He was one of our former resource counsel that gave people advice and wisdom on appellate issues, and lives down there and has 2 attorneys working for him, Shannon Mead, who's the single person from Los Angeles County who wanted to live in Machias, Maine, and did so, and has a lot of experience in the public defender's office in Los Angeles County doing some prisoner advocacy work and representing prisoners, I think, on capital cases, and is located in Machias and working with Max on Ellsworth and Machias cases. And then we have a entry-level position in that office filled by, I think it's Isabel, is it Mullins? Mullen. And so she started, I don't know, 6 or 8 weeks ago. So she's working with Max. Max has an office administrator and is looking to hire a paralegal and investigator, and is in, I don't know the various stages of all the interviews, but they're all working on filling those positions. And then you have Jesse Archer in Lewiston. That office is right across from the courthouse, and they are lucky enough to have 6 attorney positions in addition to the district defender, just based on the fact that that office serves 3 counties, and one of those is the Lewiston Auburn area, which is Maine's 2nd largest city. And so we would expect that office to have more attorneys than some of the others. So they've got 4 81s and 2 82 positions. 5 of those 6 positions have been filled. We're interviewing for the second 82 entry-level position in Lewiston. The 4th 81 is a fellow from Alaska who is moving here and starts in January. And they have an office administrator, and do they have paralegals there? They have 2 paralegals, and they've already started interviewing. Okay, so those are candidates have been identified, but we're in the throes of state negotiations to get them on board. So that's the 5 existing offices and where they all stand. And as you can imagine, there's a lot of pressure both locally and statewide on those offices to take cases and cure all the ills. There's a limit realistically to how many cases off a list of 250 cases someone can take. For example, in Jesse's region, which is Oxford, Androscoggin, and Franklin counties, there's 250 cases combined on those 3 counties on the unrepresented list. And so it's not really feasible for an office of 5 trial attorneys and a supervisor to take 250 cases on day 1 and make the list go away. If they did that, they wouldn't be able to take any new cases for 6 months or a year, and there'd just be another 250 cases on the list. So they're trying to balance taking new cases with taking cases off the list and trying to make a dent in the list.
And Freyla, you're the first district defender in Maine, so you're sort of, I imagine, have gone through a lot of what Jim was describing. Some of these other offices are currently going through. I guess I'm just sort of wondering, what you've learned opening the office in the Capital Region, and what might be what advice you might give, or what advice you give to those other attorneys starting those offices in other places.
So I'm not the first district defender. I'm the first first district
Brick
defender.
and mortar. Sorry.
Toby Jando came before me, and he will remind me if I don't correct myself, as he should.
My apologies.
Oh, no, that's fine. They get advice from me more than often than they want, probably, because we have formed a really good working group that I think we meet regularly and we consult on many decisions. Without having the support of Toby, Jandro, and the rest of the district defenders, I don't think I would be as successful. And I certainly hope that they feel supported in building the offices, because I think, to answer your question, building strong relationships with all the players in the system really is what helps you be successful. I had a huge advantage. Nobody was really looking at me when I was getting set up. I had a lot of, people knew it was coming. There were low expectations. They were maybe hopefully in the new year you'll get started. And so I had a lot of freedom in that place. I was the first one in, so I had all the attention to myself. If I needed something, there was no one competing demands. I could just say, we needed this. A lot of the infrastructure had been provided ahead of time for me. So I came in with a space. We ultimately moved to a different space, but I had a space. I had furniture. I had attorneys starting right after I started. So a lot of the infrastructure building, which I think all the other offices are doing in public with a lot of critique about this how fast they're going or what they're doing, I got to do that with complete freedom and anonymity, which made it look like I just started immediately from day one doing great. And I love that perception. Please continue believing that. I would like to continue delivering those kinds of results, but the reality is it's a slog. You have to get the right team in place. You have to get the people in the right places. You have to create systems between you and the court and the prosecutor's office, because nobody is used to dealing with an organized defense system. And in order to be successful, you have to communicate frequently with the clerks and the judges, and if they need to know who you are and how you are. I'm very lucky. Kennebec and Somerset County I've worked in for a long time, and I had a lot of pre-existing relationships with clerks in those offices, with judges in those areas. I came out of the DA's office, so I've trained most of the ADAs that we are up against. I know them very, very well, and they know me very, very well. So if I have an issue, I can pick up the phone and call the DA and say, what the heck is going on here? We have an issue. Can we sort this out in a way that I don't believe a person coming in from the outside has those kinds of that kind of access? So I feel very advantaged. But my advice to them is keep killing it. They are working really hard. They are working every day diligently, trying to get their office up and running. They're working on, we've put together trainings in relatively short amount of times to get people trained so that every person who started this year has had a training already. It's not a 5-week training. I would love it to be. Maybe one day it will be. I hope one day it will be. But as of right now, we're providing that training and oversight. We're creating the relationships with the clerk's office so that we get the cases on a regulated basis. We're at the point where we're still figuring out the forms that we're using so that the court can give us the cases and getting that communication down. So I think we've come a long way. I hope that I know that, Kennebec is perceived as successful, and I'm working very hard to make that continue. I think we are a successful model at the moment. I do believe it can be replicated everywhere statewide, but we also have a long way to go. I'm a year and a month into this, and I'm having a great time. And I'm glad that there's a very short list of people sometimes who need counsel in Kennebec and Somerset, and I will continue working to make sure that list is non-existent. But I would also provide grace and space for the rest of the offices to also come along, because they need it and they will get there.
And Sarah, we heard Jim talk about he has jobs he needs filled, and I guess I'm curious about your perspective from the law school of how we sort of staff these offices, and I would imagine having a public defender system sort of creates more opportunities for students to get into this work. I don't know, I'm just curious about your sort of perspective on all this.
Sure. So hello, hi, Sarah Branch, she, her pronouns. I only represent myself today. I do work at the law school, just to be clear. So I think that one of the barriers that has been to this work, to do indigent defense work, is what a lot of people call the pipeline. I think it's been very easy to get on the pipeline of criminal work to the prosecutor's office from the law school. I would say in the last 5 years, 4 years, maybe since the pandemic. So time flies when you're having fun. But in the last 3 years, the law school has worked incredibly hard to sort of change that, and sort of in the same way that it's a slog to build an office, it is a slog to figure out how to do that. One of the, Professor Levy is here. She runs our externship program. I think a lot of it is relationship building, it's communication, it's giving more opportunities to the students, the ones that are sitting here and are interested in this issue, but it's also appealing to a larger audience at the law school about what is wonderful about this type of work. I think that trying to build passion for what is incredibly rewarding work is very difficult when all the portrayals are a dumpster fire. And I think when you're having these conversations with students in school and you're like, okay, so you can choose to go have this work-life balance and this employment and life and happiness and whether you want to call them the golden handcuffs or whatever you want to call them over here, or you can go into a dumpster fire of a system and try and fight your way out. And so my goal is to have conversations with students to both, I mean, these are the diehards that are in this room right now. These people were going to go and give their life to this work regardless. And the obstacles have only motivated them more, frankly, because that's how they're built. But we need to appeal to the students that don't realize that defense work is their passion. And I was one of those students. I got out of the Peace Corps. I'm going to do international law. I go to my law school and my criminal law professor changed the arc of my life. One person, my life, I'm here today. And so the amount of incredible influence that the law school could have in the life of a student, I absolutely feel and I take very, very seriously. But I do believe what these students want, and I think one of the panels talked a lot about it, they're different than when I went to law school. They want different things, and good for them because we're all burning out. And what they want for themselves is both a career they believe in and a life they can live. And it has to be sustainable. And I know, at least in the justice clinic that I run, we talk about this all the time. The vicarious trauma that you experience representing people who are struggling is real. And we can't have a system that churns and burns the attorneys. Or as I think the individual that was sitting here from New Hampshire was saying, your 1 to 5 years of somebody being a new attorney, that's wonderful, but they're learning a lot. The value of someone 10 to 20 is where you're getting your most bang for your buck. So our system has to be designed to get them from year 1 to year 20, still doing this work. And the way we did it in 1994, which was great for fashion, but terrible for learning, has to change, right? We need to figure out a new way to doing it. I know I believe in that, and that's the way I teach. And I think the law school is changing that as well. And I think that particularly with Professor Levy and other people that are doing this work, we have the rural practice clinic now, we have other clinics that are trying to expand the scope, but you have to have an institution for them to go to, because we can have all the law students in Maine want to do it, but they have to have some place they can go to where those things are then perpetuated.
Yeah, I mean, we heard earlier about, I think the New Hampshire system having sort of a class enter the public defender system. And I guess, obviously we're very early on in this, but I'm wonder about the Maine public defender system, if, there's a sort of a way to create that sort of pipeline with the law school or otherwise.
Yeah. Yeah, there is, and we're working on it. We have a recruiting committee. We're working with Marcia, we're working with the law court to get our programs approved for both in-house and private attorneys to host interns and externs. Brayla's office hosted law student interns last summer, but we're lining people up for next summer. Chris and Steve have been to Boston for different law school type fairs or recruiting efforts over the past few months. What I say when I have the opportunity to say to the legislature is we need to keep building these offices out in a steady, reliable, predictable way. Because if we had 100 jobs today, we couldn't fill them. But if we don't continue to add jobs, we will continue to lose talent to Massachusetts, New Hampshire, other places in the country, or to civil practice. And I think what I recognize, and I'm trying to get policymakers to recognize, is that during law school and when you sit and take the bar, you're making decisions. Certainly 20 years ago, it was almost an irrevocable decision because you have to take the bar again if you were going to move states. But it's easier to move states now. But you're still making a big commitment wherever you take the bar that you're going to stay there. And so if you don't think there are jobs in an area you're interested in, you're going to look elsewhere. And the UBE now is portable, the universal.
Oh, the UB.
Yeah, what's the U stand for?
There you go.
Uniform.
Go law students.
Uniform bar exam. It makes it so they can move from state to state very easily. And so they can go to Maine law, they can have Maine roots, they could sit for the UBE. And if there were no jobs in something they really feel passionate about, they can move to Massachusetts or New Hampshire. We've seen this in our recruiting efforts with interviewing people who have Maine connections from around the country who express in interviews that they left because there was no public defender system. And so they were faced with either hang out your own shingle, find one of the very few jobs you can find in a law firm that does criminal law, or practice something else, or move. And so we want to continue to build that relationship, build the interns and extern programs, try to get people out of Portland to more rural areas so they can get the experience of what it's like and the difference they can make in a rural area of the state where they'll be practicing with the same judges and lawyers, and they'll know them all, on a first name basis, and they'll know, people in the community. I think that's a tryout for both the students and us. And we want the students to actually experience what it's like to do this work so that they'll know if they hate it or know if they love it. And we hope many of them apply for positions, those 82 positions. We've had people ask us about the 82 positions and whether we could hold 82 positions for graduating students. We are simply not in a position to be able to do that right now with the crisis that we're in. I cannot justify to the administration or the legislature or the judicial branch holding open positions, hoping a graduating student in May will pass the bar they take in July and they'll be able to start with us in September of 2025. So we're filling positions as fast as we can, but we hope to create more and continue to be able to draw from the school, like I said, in an incremental, predictable way.
I wanted to talk a little bit about the way public defender's system or an office kind of changes how cases are handled. For example, I did some reporting on this, and Megan Maloney talked about your office, Freyla, and she said, the public defender's office is challenging pieces of a criminal investigation that haven't been challenged before. And she says that is healthy for our criminal justice system. So I guess I'm just curious what a public defender's office sort of enables you to do in cases and sort of system-wide that, somebody hanging the shingle, so to speak, can't do.
Well, I think that Toby Jandro and I talked a lot about discovery, and I think you were there for some of those discussions. When you have an institution and people working in concert together on a critical number of cases, you can drive cultural shifts through targeted and systemic attacks on places that you perceive as weaknesses in the system. So I think one of the things that's particularly pernicious in Maine right now with criminal cases is discovery practices are extraordinarily sloppy. And we, defense attorneys complain, we're getting discovery at trial, right after jury selection, way later in the process. And that has a really negative impact on the ability to manage the case from the beginning, because if the case you're negotiating on, the case that you're gauging and gearing up for, doesn't really have the pieces that are required to prove it, your analysis of that case and your defense of that case may shift 180 degrees if suddenly evidence shifts at the last minute. Now, if this was happening once in a while, it wouldn't be that's sort of the perception. This is sort of one off. Every so often this happens, but it's really systemic wide. In every single case that we get, we know that the discovery is not going to be completed on time. And so as an individual attorney, you file discovery motions, you file, and you may have successes, and they're kind of these individual pieces. But if you're doing it all together, and let's say all of your cases, and these offices are budgeted for about, a third of the cases of any given county. But if you're filing 50 or 100 of those motions, and you're litigating that in every case, the judges are seeing these motions all the time. So instead of seeing these motions a couple times on a motion day, they're seeing 4 or 5 in a row. Suddenly you're being able to perceive patterns. The law court has actually indicated that one of the indicators of discovery practice issues is patterns. You can't even identify a pattern as an individual attorney working on cases in a singular pattern. You have to have a critical mass of cases to identify patterns across offices and across the state in order to affect change. So discovery is one place where we're doing that. I use that because it's one thing that we're working on actively right now. And we've been very litigious. I'm very proud of the Capital Region office. We're very litigious. We file a lot of motions. And the reason I'm proud of that is because we are pushing prosecutors. And if your client benefits, if you can make that case, if you drive up the time required to that case high enough, at some point your offers get better. Someone was talking about eliminating dispositional conferences. I agree entirely with what Tina said, is the process doesn't matter as long as the process is working. So the process working right now, we don't, it advantages us to drive the cases to the jury selection, because then we're seeing offers that are substantially better than they were before that. And our clients are benefiting from having the option to plead to something they may wish to do instead of going to trial. And I see our job as providing options for our clients. It doesn't matter what option they take. I want to provide the best plea options, keeping in mind their goals, and also provide a good trial strategy if they choose to try a case. But whatever they choose to do at the end of the day, that's up to them. And my job is simply to provide the assistance they need to move forward. But you're not able to do that like on a system-wide basis unless you can do that. So for example, our office has 50 cases on the next jury selection list. When you walk into a jury selection list, when you have maybe 5 cases, the maximum number of trials I've ever seen tried in one trial term in Kennebec is 5 cases. And that's rare. It's usually 3 juries are picked roundabout. You'd walk in with 50 cases, you have a leverage, you have a strategic advantage in negotiating that at that day, because you have more control over what's going to be set. You know what the cases are worth, and you're able to really kind of do a full court press in a way that is difficult for a prosecutor's office to address, because having been a prosecutor in that office for 10 years, if you have a list with 150 cases on it and you don't know which ones are going to trial, you're not able to walk into a jury selection prepared to try 150 cases the next day. And so we can sort of turn some of the structural advantages that prosecutors' offices have had on their heads and use them to the advantage of our clients with the rules that are, regular due process rules. We should have discovery in advance. We shouldn't be getting it jury selection. And if we get a jury selection, we're going to want to choose a remedy that's going to advantage our client. Ideally dismissal, but if you take out the drug certification of a case with possession, you don't need a dismissal. You're going to get one.
So do we, and this is for all of you, I guess, do we think that a robust, the full public defender system sort of implemented, are we going to see more trials and fewer plea deals? Is that, I mean, I know we can't see in the future, but I guess I can't help but ask that based on what I'm hearing.
Go ahead.
Well, I think the system is designed to be adversarial.
Right.
And if you believe the case law, okay, pressure is supposed to be equal on both sides. And I think what Freyla is saying is that before there was a disadvantage, you have the Goliath and you have the Lilliputians, and they were not united. And now the model is the Lilliputians bind up together, wrap the legs of the giant and knock it over. Or if you're a Star Wars fan, the Ewoks and the AT-ATs or whatever the things are called. So, but the idea is that the many can overcome the mighty, right? So this is the beauty of America, right? You get to question the government, you get to hold them to account, you get to force them to show their proof. And to, I think, the point that Attorney Nato made, which is prosecutors often don't know the value of a case. Maybe they haven't tried a case, or maybe they never actually called up a witness and found out, P.S. I was totally high that night, I don't actually remember. So what is written in the police report isn't actually the truth. And so the concept is, if we want justice, if that's what we think this system is designed to achieve, We're going to set aside systemic racism for a moment and how we only punish poor people. We'll put that over here, come back to that. But if we assume that this adversarial system is supposed to get to truth, then you need the pressure on both sides. Whatever plea comes at the end should be an equal footing plea, meaning the defense attorney gets to fight back and the truth is at that other end. So that then, in theory, if you believe that the system is designed right, that then ensures public safety. So accountability, rehabilitation if that's what's needed, and public safety. That in theory is what the system is supposed to do. So the public center, I believe that the collective act is needed. I used to be a prosecutor in DC and their public defender's office challenged everything from the ground up and they did it systemically. And so if they pled out in this case, they got to the point they could appeal the issue and then they got case law that then they could use in all the rest of the cases. And so the ability to work as a team to get at an issue, they would pick an issue, they'd litigate it until they got to an appellate court, then they'd have the appellate ruling. It's brilliant. It's a way to change the system because otherwise, what is it, 94 to 97% of all cases plea.
Yeah, I guess, we're here talking about this crisis, but I think sort of what we're talking about now, I guess, is sort of the opportunities to improve the system that have come out of that crisis. I guess, I don't know, are there any other ways that you see that, the crisis allowing us to improve the criminal justice system in the ways you're talking about?
Well, I think the discussion from this morning about prosecutorial power and discretion and the judicial hesitancy and pulling the levers of justice and dismissing cases are two things that could come out of this. You get to a certain point and you have to start thinking of supply and demand and allocating resources. And if the state of Maine does not do that soon, there's going to be at some point a court order, state or federal, that is similar to Oregon's, that forces the state to release people. And cases will be dismissed, and whether those people are guilty or not will not be adjudicated, and public safety will suffer. And if people are really concerned about public safety, then they need to focus more on serious violent felony crimes with victims, and spend less time aggregating the third stolen packet of M&Ms into a felony that lasts on the docket for 1.5 years, taking up attorneys' time going back to court multiple times over and over for a case that probably should be just dismissed and isn't doing anything to further justice. So those are the kind of things that could come out of a crisis, is if the state is serious about re-examining the way it's always done things. If it is not, then this opportunity will be wasted.
Yeah, I guess also I'm speaking of the state. I'm wondering what, if anything, you've heard from the executive branch. I hear former prosecutors in charge of that, and yeah, the rest of the state government about the work you've been doing.
Well, I am not one to tell the tales out of school, so I don't have ongoing conversations with the governor's office. I have a relationship with the trial chiefs. We meet regularly to talk about issues that come up pertaining to assignment of counsel and availability of counsel and things that can be adjusted to make things better procedure wise. We are working with Shira Burns on trying to decriminalize some of the driving offenses. As far as the administration goes, we're in the middle of the budget process, and so we've proposed incredibly high numbers for 26 and 27 because that's what it needs to happen. We're asking for the other 3 public defender offices for Cumberland, York counties, each to have their own, and then for the Mid-Coast to have an office. And we're asking to go from enough attorneys and staff to handle about 1/3 of the cases to handle about 1/2 of the cases, and to do the same thing on the protective custody side. We're asking for some of the things that they've tried in Oregon that have worked, which is paying a differential for some of the cases on the unrepresented list for people that are in custody or on bail, to get people in the private market to take those cases and help whittle the list down. We're asking for 3 full-time positions to try and place cases with our attorneys on the unrepresented list. We have a request for proposals in development for social workers or case managers, both for the criminal side and the protective custody side. We're seeking employed case manager positions in the budget to work to try and increase attorney capacity, because every social worker or paralegal or office administrator that we hire helps attorneys handle more cases more efficiently and takes things that are not attorney time and lets non-attorneys do those things. We're waiting to get feedback on our proposals. Like most of state government, we will not get everything we're asking for, and we will have to triage and rank priorities as we see, you know, the areas of biggest need, the biggest bang for the buck. But those discussions are ongoing, and we haven't received feedback yet or any kind of final indication on what's going to be in the administration's budget proposal yet for PDS. I expect it will be less than we've asked for, but last year we were successful in getting more than we had in the governor's budget through appropriations. They gave us the other 2 offices for Lewiston and Ellsworth and an additional $2 million to fund those offices over and above what the administration had asked for. And we got an emergency bill for Caribou and Bangor. And so I am cautiously optimistic in a state that has a $957 million rainy day fund and suddenly had $200 million show up to trickle down $75 million to the Department of Transportation, can afford a criminal justice system if it wants to.
Yeah, I mean, I think there's a lot of positive stuff that's happened in the last 3 years. I mean, what you guys have been doing, you know, and now that there's a way to get loan forgiveness, and these are the small little bites out of the apple that we have to take in order to build the system. It is a slow burn. It's going to take a while. I love the word slog, even though the visual is a little painful, but it's hard work, but it's work worth doing. And the health of the entire state requires that we do it. And part of the problem, I think, that we see in the state of Maine is that we swing pendulums a little bit too quickly. We are reactive in the way we legislate. You know, we can make great progress and then go 3 steps backwards at any given time. And we struggle with staying focused and not burning out on any given issue. I mean, it is very frustrating that we use the criminal system as a no eject, no reject system for all our other failures, whether it's in the Department of Education, the Department of Health and Human Services, or any other agency. We bring those humans who need our help in other community-based places into this system because we have failed them elsewhere, because we can't say no. And defense attorneys are a reactive agent. So we can only respond, but there are agencies that are tasked with being proactive who maybe could do more. And I think keeping that energy alive and realizing all of the good that can be done and why that's so important to the health of the state is part of this conversation. So while I appreciate the defense-focused conversation, this is so much more than not enough defense attorneys. And other people need to lift up those mantles.
Yeah, for sure. We could go. We could spend all day talking about the various, you know, shortcomings of the various systems, but that does bring up an interesting point. I mean, we talked about, I think Jim mentioned, like social workers as part of PD offices. I think the term is like holistic defense, and I guess I would just like to hear you guys speak to that and maybe the opportunities that the PD system enables for that kind of more holistic, like wraparound defense of the individual.
I have a dream. I mean, I love the idea of holistic defense. I've looked at the Tennessee Knoxville office specifically. They have some phenomenal programs. I mean, they have an after-school program and they're serving meals. That's amazing. That's a place that I put on a shelf right now, because right now what I really care about is making sure that there are enough public defenders in Maine. That in my office, those public defenders have the training and support that they need. And there's an investigator on every single case that we need an investigator on. Having a case manager is one of my wishes. That would be really helpful because the time that attorneys spend on the phone trying to get individuals connected with services that may benefit them and may help them achieve a better plea outcome. That work can be done more successfully by a case manager in the office. And so I think although I would love to sit around and think about all of the things this office could be, it's really important for me to stay disciplined on what the office needs to be right now. Excuse me. And what I mean by that is good training, good procedures, good support, so that we're keeping, training, and retaining good attorneys. We're staffing all of the cases. If we can move from 30% to 50%, I think my office is close to being ready to be in that arena of being able to build that. And then once we have that, let's first steps. First things first, before we start talking about after school programs. And I really would love to see every staff attorney position filled. I'd love to see offices in every county and a system that's actually built out and working. I'd like to see a training program. Like, again, I don't think we're going to get to 5 weeks anytime soon, but if we could get to a training program that by the first year that someone's been in a PD office, they've gone through a training, which we've accomplished so far. And that training has been comprehensive enough for us to support both our new attorneys and our more experienced attorneys, so that they're doing better cases and they're working more efficiently. So we're able to take on more of the unrepresented list. That's great. I think if we can eliminate the unrepresented list in the next few years, that's my dream right now. You know, eventually, yes, I would like to see what this system is capable of, but for the next 5 years, I just want to see the system come into effect. I want it statewide. I want it robust and functioning well. And then let's see, I know the district defenders so far are they're intelligent, they care, they're strong advocates, and they will think about ways to expand the system if and when we have the capacity. But right now, we really need to stay laser focused on, let's get a PD office in every region. Let's get a PD office in every region. Let's get that list on. Those are the two things that I would like to see us work on. Which is not to say I don't care about after school programs. I do passionately.
Yeah,
But right now, I really want to see PD office open in statewide.
I would just follow up with this, that the holistic defense, whether it's fully developed in Maine yet or not, and is widespread enough, I think the answer to that is obviously no. However, we do have the resources, and many of our attorneys in the private sector, and I hope all of our attorneys in the PD offices take advantage of the resources. And those resources are funds for investigators, funds for experts. People are starting to use sentencing mitigation experts and really fully develop sentencing arguments with expert testimony. If we do get case managers through the RFP process, those will be available to the private bar. And even if we don't get case managers as employed in the PD offices, they'll have those resources available under contract. And so I think we're moving in the right direction. I think part of our challenge is it's easy to teach a new student new tricks. Sometimes teaching the old dogs new tricks is more of the challenge, especially if they've had success or they have a certain way of doing things. And so some of this we're trying to do through our training program. I think we've had a very successful year of training. We're now paying our attorneys to go to training. The same way a prosecutor would be paid if they were sitting at a training. And I think the idea of holistic defense is something that's talked about, but right now in Maine, the delivery of that is in two different ways. One is the internal public defender office, and one is sort of the a la carte menu that the rostered attorneys have by making fund requests. And I think at every commission meeting, we report on how many of those requests came in that month, and we are hopeful that those will keep increasing. The budget for that has gone up. Some of that is because the rates for the providers have gone up, but I think it's also gone up because I think some of our attorneys are using those experts in a more creative and thorough way now, so that you are seeing, I think, more attention paid to different aspects of representation than there was even 10 years ago in Maine. So it's a good trend, but we have a long way to go before I can say that we have sort of universal holistic defense in the state of Maine.
The only thing I would add is I do agree you gotta walk before you can run. But I do think that there's a piece that I do believe at least the students are learning, and I think sort of the newer generation of lawyers are recognizing that our clients are human. And so all of these things are impacting their lives and therefore their defense. And so getting to your office for a meeting and not having enough food for the day, like how these things are, that doesn't mean the defense attorney has to fix them, but recognizing your client as somebody with complex problems that are impacting the choices that they make so that you know whether or not their decision is in fact voluntary and knowing, or if it's influenced by something else, substance use disorder, or the fact that they're unhoused, or whatever the other pressures are on their lives. I think it's important for the next generation of lawyer to recognize those things. I think it's good that we first represent people and then we learn to run by doing that holistic piece maybe down the road as a dream, but knowing that our clients are human and have these complications to their lives is important right now.
Obviously, there's still going to be, even when the fully developed public defense system, there's still going to be a place for the private bar. I guess I'm wondering if you've thought about, the relationship between the private bar and the public defense system, and if there's a way to sort of make them more than the sum of their parts.
Yes. So one of the things we've tried is procuring a jury consultant to provide services that I think would start in the PD offices, but that would be shared with the private bar as well. For example, we're exploring obtaining some software that would allow us to do some research on juror pools, and if we had a public defense office with staff able to input that data and make it available to be shared with other attorneys on the same trial list, we're going to have the same jurors and share that with the private bar. I know Frela is very conscious of the fact that there needs to be more sentencing information shared widely in the state for defense counsel. One of the first things you learn as a defense attorney is you get your case, whether it was in the old days from the judge saying, oh, he's got a pulse, I'll give him that case, or now someone on the roster. How do you judge an offer if you don't know the going rate for a charge? So one of the things we want to do is create more availability of sentencing information. We're also working on trying to organize and make useful our expert database. The database we have is 15 years old, and so we don't know without some reorganization and analysis if someone who did a shaken baby case in 2011 is still even doing that work. And so we're working on trying to organize that better and make it more updated and relevant to share that with the roster attorneys. And so I think to me, the PD office is once up and established, and whether they're doing a third of the cases or a half of the cases, they are going to be a resource for the local bar, especially for someone who's new or for a solo practice or a mixed practice where they only do criminal law part of the time because they need to do something more than 150 an hour to have a sustainable practice. Those local PD offices with experienced attorneys and district defenders are going to be like a little mentoring enclave that can work with the local bar to the extent that the local bar wants to tap into that. So I see those as having a very symbiotic relationship. And I think we've seen, some of that already start, and I hope it continues.
Yeah. Have you had the opportunity to sort of dip into that, Frela, yet? Yeah.
Yeah, absolutely. Yesterday, in fact, an attorney who was in the area was in a parking lot doing work, and I was like, just go on over and sit in my conference room. Like you got warm, we got water, like don't work in your car, like come over here. Cause you have people who are roving around, they have 2 hours to kill, you know, she's reviewing discovery in her vehicle and like I have a conference room, like,
Yeah.
please
I-
come over here and sit there.
I know Toby has the same,
Yeah.
he's got a setup for rostered attorneys
Yeah.
in the Caribou office who need a workspace and they're away from their home office in Caribou, trying to go to court. They could land at the PD office and have a place where there's, internet and, the ability to use a phone and make some calls or do some other work, whatever needs to be done.
But also just sharing motions. So we try to do a good job of sharing motions between practitioners, in court. If anybody needs something run over and filed, I know with electronic filing that's down, but sometimes people are like, this hand delivered. Some of my office is always going to be headed over to court that day where I'm like a mile from the court. So we try to be really available to practitioners to sort of to do that assist. And then again, I definitely have lots of conversations with attorneys who call or like, you talked about this immunity motion. Can you run me through this or send me a copy of what you filed? Or, I'm about to do a bail hearing, new attorneys, I'm about to do this. I've never done a B&B hearing. Can you just talk me through what that looks like nowadays? So we try to be really available. We have a great relationship with our local bar. We for a while, we were having them come in and meet with the attorneys so that so my attorneys could meet them and they could meet us. And just kind of talk to us, but we have a pretty congenial bar. And I know MacDill has done a lot in terms of making sure there's a good community, and we want to really support that where we can. Because I think as much as I'm very interested in creating institutional structure. We're always going to have contract counsel, and we need to make sure that they are valued and that they're supported as well. And having come from that, I was a solo for a long time ago. I burned out because I didn't have a community and I didn't have the support that I needed to be successful and feel successful. And so I became a prosecutor. This is a different story. But as soon as the PD offices became available to me, I've come back over, and that I love what I do because I do it in the structure that I do it in. I would not be as happy if I stepped out into private practice tomorrow, even if I was doing the same cases. I think fostering that sense of community is a responsibility that I know my office takes seriously, that other district defenders have talked about as well. And I think it's important to our entire community because we are countering the state. This is a giant, monolithic, powerful being that has all of the leverage in this cases. So we need to work together to be successful. And if we're working against each other, it's self-defeating, and the people who are gonna pay the consequences are our attorneys, or our clients, sorry, not the attorneys. It's our clients that are gonna suffer if we aren't able to use whatever collective power we have in opposition.
And the inverse is true in a way too. I mean, having 50% or 2/3, whatever we end up with as a split of private versus institutional defense, we don't have a monopoly over good ideas. And so when you have 200 or 300 private attorneys doing this work, they are going to come up with theories and new ways of doing things that we might not institutionally be thinking of, that we can also benefit from as well. And so it, to me, is a good opportunity for this sort of cross cooperation and, I don't know, cross pollination, I guess, if you will.
Sarah, forgive my ignorance on this, but how much of this intersects with sort of the youth justice world and, I don't know, any impact in that area?
I could quote Whitney Houston, children are our future, right? So the Youth Justice Clinic does what I think a lot of what we're talking about, in that we focus on children accused of crimes. We define children up to the age of 25. So we are in both youth court and adult criminal court. We bring a lot of the adolescent brain development into our representation. So we do all those things. And we teach a skill set, which is I think what they're looking for, at least I hope they are. We teach from the ground up best practices, how to represent clients, so I think what we maybe have just overlooked is how much fun this work is. So when she's saying, we're going to challenge all this discovery, I'm like, that's awesome. Like, what are you doing? Like, let's talk about that. We just talked about discovery demands the other day. I love this stuff, right? This is the fun. This is why you do this work. It is fun. It is intellectually challenging. Put aside that we all love the Constitution and we want to believe and uphold it. even in 2024, this doing defense work is fun. Is it always fun? Do we win? Winning needs to be redefined. That's what I would say, right? Success, you need to look at the different ways that you can view it. Is your client feel like they have a voice? That can be your success for the day. Have you filed a motion that then triggered sort of a ripple effect in the system? That can be a success. And so a lot of what we do in the Youth Justice Clinic and what I believe in terms of the representation of youth is, one, too many are in the system, period, full stop, stop bringing them in. But two, these children that are not getting the services that they need or not getting treated properly by the system itself then end up as future adult clients. And so again, going back to what in theory is the role, right? That public safety piece, we're only making it worse. All the data is clear. This is not just a defense attorney's perspective. Bringing children into the system, locking them up, shackling them, it only increases how many times they offend. And so all of this stuff is exactly what we do in the Youth Justice Clinic. And, I think that the students, what I see is cyclical with the students. And I've only been at the law school 3 years in January, but it is to the student almost that sort of the first time they go into the courtroom, they stand in front of the court or something happens, there is this sense of, well, why did that happen? That's not fair. This system doesn't seem to be working right. And then that either inspires the passion and like they start getting the fire, and then we just fan that flame. And then hopefully they then want to do this work going forward, or they go on and be a lawyer in a private firm. Maybe they do pro bono work, but they've come to law school for a reason. And it's whether or not we can channel that into both good litigation skills and someone who cares about a justice system.
We'll take questions here in a minute, but I guess I'm finally, just for all of you, I'm curious, if we look back, we jump in the future and we look back at this moment, sort of, I'm curious what you would want the system to look like, the public defense system, maybe the criminal justice system at large, however you want to take this, in say 5 or 10 years from now. Like what would you like to see it look like then, based on the work we're doing today?
You want me to start?
Sure.
I would ideally like to see people getting assigned attorneys at initial appearance that was their attorney for the duration of their case, and that the lawyer of the day phenomenon, no offense to you, Rob, no, he stepped out, so it's an opportune time. It is a sort of systemic Band-Aid becomes a thing of the past and is very rarely used in the situation where you just have sort of a surprise guest show up that wasn't on the list, and so they don't have an attorney. I think building out the public defender offices up to at least 50% capacity would allow us to do that. At a third capacity, we do not, I don't think, have the resources that we want to dedicate to covering all the lawyers of the day. I think that's taking away from taking on cases, especially when you have 1,000 matters with no attorney. But in the future, I would like to see Maine really fulfill the Gideon promise and follow what's in statute, which is someone gets a lawyer the first time in their court, and that's their lawyer for the case. And that is possible if we continue to grow the PD system, while at the same time valuing and continuing to develop the rostered attorney program. So that is, I think, one of the long-term goals I have.
Yeah, I want VCRs to go away. It's my dream.
We could take away. I agree with both those dreams. Those are great dreams. We should change the law on that. I agree. I love the idea of vertical representation. It's best practices, and they piloted it, and we worked with Maine public defenders and the judiciary as a concerted effort. We piloted it in the district court for juveniles, and then it spread throughout the state of Maine and now is statewide. And so now all children, and from a bill last legislature, so shout out to all the legislators who supported it, all children are considered indigent for the purposes of appointment of counsel. So now at the earliest possible moment, every single child accused of a crime in the state of Maine gets an attorney for their entire duration of their case. It is wonderful to pilot it in the youth context because it is our smallest population, and we were just talking about this. It also makes the biggest impact because children are impacted by their representation to the extreme, but also it models the programming for both clerks and law enforcement and the people who are doing this to show us that we can do it. And I think we're tracking the data now to hopefully see how it impacts the longevity of that case. So it can be done. I think it's a great idea. I would love to see the list gone, and for us to decriminalize some things that aren't impacting public safety.
Great. Does anyone have any questions for our panelists?
Anyone?
We have a mic making our way
Get
around here.
That's right.
I'm gonna be a jerk.
Great.
So stipulated.
I'm gonna talk over here so it doesn't feedback. I think it was you, Sarah. I just want to correct a statistic that's off-cited, but it's inaccurate.
Okay.
97% of cases are not resolved by guilty pleas. This is an important distinction. I would say 97 to 99% of convictions are obtained by guilty pleas. And the reason why that's important, I'm seeing a lot of new law students and people who are starting out. There is a ton of room for advocacy. I would say half of these cases go away short of a conviction. So I want to emphasize that this is not 97 to 99% of the garbage brought by prosecutors is worth a goddamn. Okay. I just want to be very clear about that. You have lots of opportunity and lots of room and space to fight for your clients and get results that are not an inevitable guilty conviction. Okay. So I want you to all to keep that stat in your mind and to just be very precise about your language there. We're not just pleading people out because the state has awesome cases and there's nothing else for us to do. We have a lot of work to do, and that's why we need you all in the trenches with us. So thank you.
Thank you. Fair point. In precise language, and we talk about precision all the time. I do think it's really important to also recognize, because Barbara Taylor's sitting right in my eye line behind Tina, to realize how important what Tina's bringing up, that advocacy piece is, especially with individuals who are not yet citizens, especially going into 2025, how much what we do is so important in terms of our advocacy for non-citizens who are accused of crimes. And so this advocacy piece that Tina is so rightly lifting up is even more powerful in those contexts, because adjudications or convictions of any sort will impact the lives of non-citizens so much more draconian and dramatically. And so defense attorneys need to be on their guard to make sure that they are making the right inquiries and giving proper advice on those topics. So again, thank you so much, Tina.
Can you hear me? Yeah. I'm listening to your conversation this afternoon as opposed to the conversation to the late morning. This question comes to me. The way this system that we have now, in terms of the various offices in the different parts of the state, appears to have developed in stages, with various, first up in Aroostook County, and then we have the roving defenders, and then we have one here. And the legislature seems to, in the form of the legislature, saying this we're going to put here, we're going to put so much there, and so much there. But I don't hear a resonance of a system to provide defense services for the state as a whole. That is, I hear something about we're going to have an office here and an office there. Where is the transition from this legislature-built system to a system where there will be somebody who sets priorities, who says, this is where we need the work, this is what we need to do next, this is where we need the people, and so forth, as opposed to kind of reacting to what the legislature is willing to give you?
Well, I think we're doing that now by advocating for what we want. There's no statutory chief public defender or defender general, but we are at the staff at the commission and then at commission meetings putting the proposals down that we want in the budget. And so we're trying to create the system that we want. We have to live with whatever the legislature gives us. I do think long-term, either the executive director position needs to be modified to make it clear that that position has the ability to advocate for statutory changes beyond something the commission votes on, or there needs to be another position created as such as a chief public defender or defender general that isn't relying on the commission, which is a politically appointed body, and in my experience does not have the appetite for advocating for changes in the substantive criminal law. They seem to be more interested in tweaking areas that deal directly with our mission and not wading into major revisions in 17A, for example. I think we need a presence at criminal justice like we have at judiciary. And if I don't know that I have the capacity to do both. So in the future, I do think it makes sense to even maybe think of making this a constitutional office, because what we often hear in state government is when we ask if we can do something a certain way, we're told no, and we say, well, the AG's office does that, and oh, that's a constitutional office. So they get all these exceptions, and so I think when we're done with the house on fire, and we can pay more attention to the house we're trying to build, and we have our financing lined up, those are things I want to turn my attention to, and that I think that's more of a long-term sort of defendant advocate type position. We are asking for a Shira Burns equivalent position in our budget ask this year, where we would have a full-time person to work on lobbying and grant writing, similar to what the Prosecutors Association has with a paid AG position. So I hope I answered your question, Peter.
I'm just wondering how we make the psychological and the overall kind of governmental, political kind of shift from trying to put out the fires with what the legislature gives us to an agency that is really a proactive kind of responsible agency, saying the buck stops here. We're the agency that takes care of the criminal indigent defense in the state of Maine.
Yeah, I think that's just both a psychological shift, but also sort of a circumstantial shift. I think it's difficult to worry about higher functioning things if you're not breathing, right? So we don't want to be rearranging deck chairs on the Titanic. We got to plug the hole in the hull, and that's kind of where our focus has been.
Luke, hi. So I've got two questions. One's a friendly one for Jim for the end, which I'll hold for now. But the first question isn't unfriendly, and it's not necessarily for Jim. I was thinking about something, Freyla, that you said about, yes, Professor Branch?
Didn't say anything.
That's what scares me. Freyla, about, maybe when you get up to 50% of the list, for example, or the waiting list has gone away, to then look towards next steps for how to tweak or what to add to your office. Roughly, did I get that sort of correct? That comment?
I think so.
What do you see?
Yeah, my 5 years, I would.
Yes.
Well, it's a statewide vision, but yes.
So I guess the question I have is, for the percentage of clients you have now, if there are things that your office could do even better, not better, even better, because you're doing great work. Don't the 30%, just to use that, number for purposes, deserve an office that's trying to get those extra resources to do the things that maybe are potentially on your back burner, not back burner, but put out the fire first burner? Like, I understand there's only so much you can do, but if when you're looking at it, and it's easy for me because I don't have an office the same way you do, even though I have an office, it's a quilt office as opposed to a purpose-built office. But when you're looking at a client, and like, if I had the person that could gather in, and specialize in making the connections to the caseworker and getting the plan in place so that I'd have a sentencing argument of not only this is what he or she needs, judge, for a sentence as opposed to imprisonment. We have now that they are engaged with the group home, they have a caseworker, here's their med management plan. And you may already be doing that, but in terms of the holistic defense question that Josh asked about, to the caseload capacity you have now for the offices to try to get those other things for those clients they have now as well.
I'm going to try to answer your question. I think there's a question in there. So when I referenced like the holistic defense, the way that I've been educating myself about that is that term specifically is fairly controversial, and there's lots of different feelings about what that means specifically. Referencing the Knoxville office with like after child care center and feeding people, that I think is incredible. The work that they do in Knoxville specifically is incredible. I don't think we're there yet. In terms of what you're talking about, I see that as my job right now, which is basically mitigation. What we do in my office, I would like to have a case manager to triage bed placement so that we were faster on them. But that doesn't mean that we're not doing that. Right now that means the individual attorneys are working with what the resources we have. That's intensive forensic case managers at our jail to find placements if that's what our clients want and need. Want first and need, because what we think they need is not necessarily what they want, and our job is to do what they want. And sort of like meeting people where they're at, but looking at generating mitigation. You could spend, how much time do you have generating mitigation for specific clients? And specifically on bigger level cases, I'm thinking arsons, which sometimes are profit motivated, but the vast majority are directly connected to mental health. And you have some, the mitigation that you can go into with those cases where the sentences are in the double digits, often when they start the negotiations, can go on for days, months, years. Experts, mental health experts, specific, when you talk about Title 15 after competency, you're talking about NCR, and then does NCR a good job or not? Does that, does your client want that or not? And then it goes to, mens rea defenses, and then you can go to what does this person need to be safe in the community, and can I leverage that into a plea agreement? So I think when I say holistic defense, I'm not talking about basic mitigation. That's an expectation in my office that people are doing right now. And I know they're doing it because I have conversations with them. We talk about it. I'm talking about like the next step of developing infrastructure for clients and services that are outside the traditional legal services. If you're talking mitigation or like trying to work on an outcome for your client that's going to serve their need, whether that's a trial, whether that's a service they need, notwithstanding the plea agreement, or whatever it is. That is something that we definitely do. We would be doing it more efficiently if we had more resources, specifically around housing, more than anything else. I had a meeting with some housing folks trying to get some inside, like, I would like to have somebody who be the keeper of the knowledge of that in my office, right? Of where are the resources statewide, where are the waiting lists statewide for resources, how to get people bed vouchers, how to jump the line, because everybody jumps the line. So at this point, getting in line doesn't even make sense. You have to jump the line to get kind of into a position to get into housing. And it goes, housing is sort of the basis where most other positive things can flow from that. So when I say that holistic defense is something I'm thinking about in the future, I'm talking about non-legal aspects. I'm talking about building community on a larger scale. And sort of that we're able to bring people in and service them and meet them in a variety of ways. First, we need to meet their legal needs. But what you're talking about, generating that mitigation, getting people connected with services they need, that's garden variety legal services at this point in my head. That might be, I think 30 years ago, that may be not the same. I've definitely been told, like, you're not a social worker, you're a lawyer before, but from both prosecutors and defense attorneys. So like, I'm not that mentality, I think, is going away and should be going away, because we do have to look at people as whole people. I think as Professor Branch mentioned, and sort of meet those needs. But no, when I'm talking holistic, I'm talking about that kind of specified term that like some in the offices from what I'm reading this, because I'm reintroducing myself in the last year to this field more specifically than I was when I was a prosecutor. But there's a very big conversation about what is holistic and what's not holistic and what's community-based and whether they're the same thing or whether they're different. I'm not at a point in my career where I want to enter that debate. I want to build offices that are meeting the people's needs right now. And then eventually I would love to enter that larger community conversation, but after we have our house in order.
Client level, holistic defense, the whole client. And then the example from Kentucky of the sort of systemic holistic label with the after-school programs is a different thing. So I thank you for that clarification.
Of course.
Yeah, I would just say, Rob, to supplement what Freyla said, just to make clear that the in-house PDS attorneys have access to the same experts and private investigators and those Chapter 302 services that the private attorneys would have. And so I don't view any of our line attorneys as being responsible for putting out a system fire. Their attention is on their individual cases and to do what's necessary in that case. And so, and I think that's what they're all doing. And there's been, each office has considerable autonomy for the district defenders to authorize the retention of those outside experts and private investigators as they need them. We certainly want to set the example for utilizing those services, and that's not something we're cutting corners on in some effort to put out a system-wide fire. I just want to clarify that as well.
Good afternoon. My name's Allie Bronner. I'm an attorney in Rob Ruffner's office.
My condolences.
No condolences needed. It is truly one of the, and this is not bullshit, like. It's a great office to work in, and I've heard a lot of the speakers today talk about younger attorneys. Hello, I am one. I just finished my first year of practice. I think I said this to somebody earlier, feel like I'm not like standing on Bambi legs, like I know where the bathrooms are in the courthouses, etc. But a question that I have that's been coming up during the day is this push and pull that I think everyone who is an attorney finds themselves in, which is like the nature of adversarial litigation, right? That there's going to be some contention between you and opposing counsel. And I find myself constantly questioning my approach in individual advocacy, where the relationship with the prosecutor is important to keep, and the advocacy on an individual scale is really important to just go full throttle. And as a young woman, there's the gender politics, there's the age politics, there's the time of day and who's eating lunch and all of that. But knowing that like the systemic is the individual and the individual is systemic, and everything that we do for one client, we're doing for everyone at the same time. I'm just curious if you all have some experiences that you could speak to about how you're able to navigate that kind of like really mind-filled landfill. I mean, obviously I have Rob Ruffner's example to not live by, but just kidding, Rob. Please don't fire me. And I don't know, I'm just really curious, especially those of you who have gone from defense to prosecution and back to defense again, and fairly like really curious if like how you maintain those relationships with the office that you had before. Yeah, any information is welcome.
Well, my worldview is kind of like most of everything is built on relationships. So like if you think about one of the benefits of working in Maine is that it's a small town. And so you have the benefit of usually people know of you even before they know you, or they know someone who knows you pretty quickly. And so that reputation is crucial because it lives with you kind of forever. It doesn't mean you can't change it, but you carry it with you. And so I think building really good relationships with people that you work with is really important. You can have a great relationship with someone, and you should be able to have an absolute knockdown, drag out, adversarial fight with them and maintain those two things. It's not always possible, and it's not always possible with all people. But you should be able to advocate very effectively and ferociously, I would say, on behalf of a client. And at the same time, not stray into a place where you're personally attacking opposing counsel. And you know, and that's, you're gonna have varying degrees of success with that, with different personalities that you encounter. So there are attorneys who I see on the other side, and it's like, okay, so we know each other, this is gonna be fine. And you can rely on that relationship to be more effective and maybe even be faster and more efficient. You know, and then there are some people that you may have some negative of history with, or you may have an unpleasant interaction with, and so you may be more guarded with them. That tends to slow things down and be an obstacle to good negotiation, because it starts with basic trust. But I mean, you just do the best you can with what you've got. You got to be yourself. You've got to, you need to be trustworthy. So, you need to be effective, and you've got to make sure that the relationship goes beyond that case. But it's not always easy, but that's the nature of the business. It's not always comfortable either. But I think if you just keep doing your best and focus on what's important, which is what's in your client's best interest. What does your client want you to do? What's your job there? And to the extent that you can let some of the personal stuff go, which is hard at times to do, you're better for it. I mean, it was an awkward day walking into court as district defender when my entire old office was sitting across the aisle, and they were like, yeah, literally called traitor, or betrayal, or you're dead to me. And then, people greeting me with like, do you want to get coffee later? And then the defense attorney's looking at me like, I can't, why are you, like, you're invaded our space. It's like, I'm one of you. And they're like, but really, why are you over here again? And so, there are moments in time when you just have to be okay with it. Like, you know what you're doing, you know why you're there, and you can't let everyone else's get in your way. You just got to do what you got to do. But I think if you just remain, again, do your best, advocate as ferociously as you can on behalf of your clients, and serve their interests, and don't let things get personal. And when people go there, I don't tend to meet them. I don't make things personal. This is not personal. I've said that actually 100 times since I've taken this job with motions I filed. The discovery motions are not personal. They're not a personal attack on your integrity. This is my job. And if it's making it harder for you and that makes you sad, I'm sorry that you're having a bad day. Like, here's my next motion. It's not personal.
I just I don't disagree with anything Frayla said. I agree. It is not personal. But I do want to lift up the reality that, yes, we live in a small community and the small bar is wonderful, but it can also be problematic. We are afraid of the other in our bar. We are afraid sometimes of zealous advocacy. And people do take it personal. And I think it is because a lot of people's mental health is suffering and they're internally unhappy, right? They're struggling. And so when you file that discovery motion, they do feel like it's an affront, and they may take it out on you. And I'll name it, as a woman, and in there's not a lot of female, there's the last time you did the poll, how many female defense attorneys are there? So there's more of us now, but it took some time. And then add to complexities of, you're an attorney of color, you're coming into Maine, all of the other things that play into bias of your opponent and what they think you're bringing to that moment and what they read in terms of your approach. Do they read me as a little bit too aggressive for a woman? Is that me or is that them? Do they see my, white male student the same way? So I think there's some realities we have to name when you're doing these negotiations. That said, I agree fully that you have a role to play, a job to do, and you shouldn't make it personal, right? I think in the youth justice context, it's really hard because there's this concept that we're a team. And I agree with that to a line. And that line is what my client tells me to do. And so the minute that what my client tells me to do is not with the team, that is when we litigate. And I will tell you that that's not playing well right now, because the culture within the youth justice world is this team approach. And people are really struggling with that type of advocacy, and it does have a ripple effect. So I want to name that it's hard. You got to keep doing it. We call it in the justice clinic, like at least I do, the backbone moment, where you just got to stand up anyway and object. And that's our job, and it can be uncomfortable. And I agree, the more you do it and people see it is what I call your practice and not personal. I don't do this just to you. I do this to everybody. This is my motion for discovery sanctions. It is what my ethical obligation is to my client. I will do it. And you, as a state actor, are fungible. This isn't because you are on this case. So keep it up is what I would tell you. And feel free to call if you're having struggles. No, seriously, that's where that community piece comes in. And that's where that sustainable practice comes in. And I know I'm here for you. I'm sure Freyla's here, Tina, I'm naming all the people, right? Like this is what this is the beauty of the small bar, because we'll pick up the phone.
Any other questions? All right.
Yeah, you had the offensive question that you didn't
Oh,
ask.
great.
Asking for a takeaway for everybody here and everybody listening. You know, there's the easy parts of your budget ask in terms of that are to understand, opening up the other defender offices and then potentially increasing the percentage they're staffed for so they can take a larger percentage of the cases based on their staffing. What would be the next thing that if there was a thing that is, you know, isn't an elevator pitch, it needs some legwork to get traction with the legislature. If we were to walk out of here with this and talk amongst ourselves and talk to our neighbors and talk to our local legislators, that you'd want them thinking about before you have that first meeting with the new judiciary, that's not just the public defender's office, which I think you've done the groundwork on for them to understand the need for that already. What's the next ask that you would be asking for that's not?
Well, there's a couple on the list that the state of Oregon issued a report. I think it's Jessica Kampke is their executive director of their commission. It was in July. Besides just having a city named Portland, they're also like Maine in population density. They are 3 times larger than us geographically, but they have 3 times as many people. So we're side by side on the US density chart. And so a lot of the stuff that's already happened in Oregon is instructive here, and their report is instructive. They've placed over 1,500 cases off their unrepresented list by having in office staff work those cases. 3 people full-time, that's all they do is make phone calls to their bar trying to place cases, and they're asking for a couple more. They did a retained rate study. It came out that the retained rate for the defense work was $335 an hour. I think they're paying $165 for an hourly rate to take cases and $200 to take cases off the list. And so what I would be wanting to echo from Oregon is, number one, patience. Even with all those resources, paying a differential, full-time staff, placing cases, and adding public defender offices, they predicted it would be March of 2025 before they had the unrepresented in custody list worked down, and March of 2026 before they had the unrepresented list taken care of. And so the watchword there is patience. And then in our budget ask is those 3 clerical positions to try and place cases full time. We're doing a pilot project right now with Taylor Kilgore on PC cases in Lewiston, where we're paying her as resource counsel to try and place cases off the unrepresented list and see how effective that is. We hope to have some data on that to help us support that ask in the legislature. And then we're asking for a stipend of $5 million over 2 years so that we can pay an hourly rate differential for cases on the unrepresented list. To be determined how that would work and what that would be, either 25 or 50 an hour. Maybe there would be a differential between the in custody unrepresented and the not in custody unrepresented, but something to incentivize taking the cases off the list. So other than the public defender offices, to me, attacking that list is sort of the next priority. And those 2 budget items are geared to that. And then the other thing I would say is somebody's car key is laying on the floor under that seat and it fell out of someone's jacket pocket. So don't get all the way out to the parking lot. So
That'd be me.
are you all set on, you got that?
It's right by my coat,
Got
so
it
it's in a good
spotted.
spot.
You,
Yeah,
you just planted it there this
Yeah,
whole
right.
time. So those are the two other budget priorities that I would name. Ellie's here, so she made. Yeah, the central office staff. I mean, yeah, so Ellie's where all the brains are, so she said central office staff. Well, I think, what I think we should say on central office staff is that we've gone, when I started in May of 23, it's dog years in here. We had 22 people, including 9 financial screeners. And now we're up around 75 employees, and we're still basically trying to manage that and the outside attorney roster with the same central office staff. And so adding more depth to the central office staff, I think, helps the private roster and the public defender offices function better, and the commission as a whole function better. So that has to be on the radar. That's not as sexy as a new public defender office or, a program to get cases off the unrepresented list. But to smoothly implement all of this, I think we are understaffed at central office.
Any other questions? All right, let's have a hand for our panelists.
Rob Ruffner, thank you all for coming. First of all, taking time out of your day to be here, for listening via Zoom or listening to the recording later on. I think that we can all appreciate that this is a big issue. It's a multifaceted issue that is going to require many conversations, sustained efforts, and to be willing to reevaluate our positions as things change going forward and be open to new ideas. I want to thank the Maine Monitor for partnering with the Maine Indigent Defense Center to put this on. Josh and Stephanie, the moderators. I want to thank all of our panelists who are here and not here for taking time out of their day to provide additional information, perspective, and lessons from Maine and from afar. And I hope that you will all take away from this the need to engage a wider portion of our society, of Maine and Mainers, in this conversation, and so that a larger segment of our community is aware of what's going on, aware that there is an opportunity to make progress, to improve outcomes for individuals who are charged, for victims, for society as a whole, and that many of you will invite a neighbor next year or two to join us in the conversation. Hopefully we'll have another one of these next year, timed slightly better with the legislature so more of them can participate. But I also want to thank the students from the 6th. I know that this is a crunch time of year in the semester. I appreciate you taking the time out for being here. And again, I want to thank Mika and Emily for putting this together, and Emily for everything else she does at the Maine Indigent Defense Center. Really, anything that you think I've done well in the last year and a half, Emily has been greatly involved with. And all the other stuff, it was just me. So thank you very much. Safe travels.